Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addicts live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please, verbal fucking.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Top of the morning to you. It is Podcast Thursday, which also means it's Recycling Day, which I think we forgot to take out. So we get to wait 2 more weeks to our recycling. All right. Welcome, one and all. This button is not working, and I don't know why. I think if I just restart this computer, it'll fix it. Yeah, let's just do that. Let's just restart this one. Who needs this computer, right? It's just the one I'm running the stream on. They're good. Yeah, we'll restart it. This is why I love hardware and not software. Kristen Hyde, before I comment, let me check the Twitter webs. Is it something we can comment on, or does it get too political? Let's see. Let's see. Oh yeah! Wow. Computer's rebooting. Hang on. Good morning. Good morning, one and all. Sounds like it's an Epstein-related issue. We have to give the internet away, which means, well, that computer would be the one to do it. Let's see. Don't look at my password, guys. Don't look at my password. There you go. Okay, that's my password. It's logging in. It's an Epstein thing, right? Are we talking about the same Prince Andrew? Epstein Island connection? Recovery Addict's password is Pickles. Spicy maple bourbon pickles, to be precise. But you have to get the capitalization right. All right, let's see. See if everything turned back on the way it's supposed to. All the things are loading that I don't need. That's great. And hit this button. Bingo! Look at that. I fixed it just by turning it off and on again. Tell you, sometimes it pays to be a genius. Today's that day. All right. Good morning, everybody. Welcome. I'm not quite better, but I'm heavily I'm heavily medicated, which may or may not be a good thing, depending on how things go this morning. Come on, let's quit Hive. I don't need that. And I have like all too many tissues. So let's see, quit my Hive Bridge. Hive Bridge is cool. Oh my goodness, this is cool. Some cool software, cutting edge stuff. Yeah, I didn't see anything new about Prince Andrew on the internet. He's been included in that circle for a while. In the allegations. Let's see. Okay. Oh, now we're launching Steam. Don't need Steam either. Okay, hold please. We need this. All this effort was just to get this in the right place like this. Ready, set, go. There we go. Okay. Now I can say, Britta Aller, congratulations. You were first in chat. Thank you for being prompt and punctual. We're going to punish your promptness and send it to you to internet ownership. Everything IP related worldwide is your responsibility. Oh, he's been arrested now. Ooh, that would be the first arrest, right? I mean, aside from Maxine and Epstein himself, isn't that the first arrest? Wow, that's going to be interesting. All right, I did shave my beard. It was an accident. I did not intend to shave the beard when I started out. If he's been arrested, that's big news. Oh, wow. All right, we have a fun day ahead of us. We have a day of a little bit of court hopping and day 2 of a trial in Judge Stephanie Boyd's court. It's a murder trial that happened 24 years ago with somebody fleeing the country and then just being extradited 2 years ago, and now it's finally going to trial. It's an interesting one. It's going to be quick, and it will take us right up to Corey Richins, which starts on Monday, which I am so excited about. I will have to say that Corey Richins does not appear to be a whodunit so much as how they done it, which is going to be a lot of fun. Logistics of arresting a member of a royal family. Oh, I imagine that's got to be some upper command people were involved in that decision for sure. Charges of misconduct in public office. He's not a prince. He was stripped of his title, arrested in the UK for misconduct in public office. So not necessarily related to the Epstein thing. The man formerly known as Prince Andrew. Let's see. Today happens to be Andrew's birthday. Are you serious? He's arrested on his birthday? That's great. Happy birthday. We won't be singing to him if that is his birthday. Boyd trial resumes at 2:30 Eastern, according to the docket. That's why we have half a day of court hopping, and we've got some great courts. We've got Judge Simpson, who's already stacking a lineup of characters in the Zoom. If you look at this, we've got a few people that are already just, it's going to be good, right? It's going to be good already. So we'll keep an eye on that as we get started. I think it's Sudafed. I'm on the little tiny congestion nasal sinus 2 red pills where it said, if it causes sleepiness, consult your doctor. If I just pass out, somebody just text Mrs. R.A., be like, hey, you might want to check on him. He normally doesn't sleep this long on stream, something like that. So, but I should be okay. It said non-drowsy, so I'm up for it. All right, I watched the 48 Hours episode of Corey Richins last night, and I'm ready for Monday, says Chrissy Powers. It's going to be so good. It's going to be so good. I can't wait for the spiciness of court and the greatness of the judge, all combining into one huge 5-week trial. All right, Simply Nikki, member for 12 months, says, hi, y'all, 12 months. Yay, Nikki. Thank you very much. Congratulations on 12 months in that orange courthouse. It looks great. Let's see. Darlene Todd says, can we add Kyler to the birthday list? Who is 5 years? Kyler, the big 5-0. No, just the big 5. 5-0 will come soon enough. Trust me. It comes before you're ready. Happy birthday. We're going to add you, Kyler, to the list for sure. King has issued a pretty good statement. We might take a look at that. I guess it's not politics once it's crime, right? I mean, the two go hand in hand. But already on the list. Wonderful. Here we go. Red Pen comes in with the birthday list. Thank you very much, Red Pen, and to all our amazing mods for the great work you do. We have birthdays for B-Bob, Camilla, Juliana, Kyler, Dream of Laundry, Care Honey, Aurelian? Is it Aurelian? Is it Aurelian? I need somebody to spell it out phonetically. Pat, Robert, and Sean. All celebrating birthdays. Aurelian. It came straight from the source. Look at that. Yep, Aurelian. There we go. All right, we're going to sing happy birthday to these wonderful people who are celebrating birthday today. And by we, I mean all of us, wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with the neighbor, and warm up with me if you will. La 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 la. Something about having a cold makes me be able to sing better. Between the sniffles. Happy birthday to you. Happy birthday to you. Happy birthday, B-Bob, Camilla, Juliana, Kyler, Dream of Laundry, Care Honey, Aurelian, Pat, Robert, and Sean. Happy birthday to you. Okay, I fit a few too many people in that verse. But B-Bob, Camilla, Juliana, Kyler, Dream of Laundry, Care Honey, Aurelian, Pat, Robert, and Sean, happy birthday. There are many wonderful days, but today is your special day. And I realize there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully you can turn that joy back to you, make your day just a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. That was the smoothest I've ever done that. First try. Happy birthday. Do enjoy this day. It is a Thursday. We're going to bring you a special podcast just in your honor. Good stuff. Much improvement from last week, I promise, because we have different stories. Last week was bad. Oh, yeah. Good fun, though. I learned the signs for penguin and dance today. Penguin and dance. Do you know like the whole alphabet when it comes to like the British alphabet when you're doing sign language? You have like a hand you paint on and a hand you paint with. So it's like A, B, C, D, E, F, G, H, I, J. It's like a two-handed thing. In America, it's just like A, B, C, D, E, F, G, H, I, J. I know the alphabet and a few of the other signs that you use like in traffic, but that's about it. Good stuff, all of it. Dancers doing their thing. We have today arrested a man in the 60s from Norfolk. Oh my goodness. Didn't even name him. Drum solo, here we go. Can do the ASL hand alphabet too. I can do the you're number one in my book. Oh no, that's the wrong finger. It's similar to that, but I can do that one. That's also a driving hand signal. And there's the one that they do in England. It's a hand signal just for driving in England. That something about turn this way, that way. I don't know. I don't know how they. Yeah, starts with a W. Can't do that one on stream. That will get me in trouble. Lots of fun driving hand signals you can learn. Probably the easiest ones to do. Camila Juliana says, all I want for my birthday is 1,000 likes. That's it. All right. Good morning. Let's jump to court. The judge is here. He's getting set up. So let's
call case People versus Avon Johnson.
Let's see what we're going to do.
Carolyn Foster Tucker on behalf of Adrien Johnson, standing in for attorney of record at Drukas.
You don't even know the attorney of record's name?
And I had this as in custody. Where is he?
He is in custody.
Oh, there he is. Mr. Johnson, can you state your name, please?
Jacob Fike has been here since like early hours.
If you just talk, Mr. Johnson, I think you're unmuted, sir.
Talk louder because you're far away from us. Such a crowd of people here. Detect Vids.
Mr. Johnson, can you hear me?
Thank you.
I don't think he can hear me.
You showed up to court, Judge. You can't issue a bench warrant.
That okay?
Yes, sir.
He's like, hey, can somebody help? Guards.
I don't know, because I know I'm not hearing any background noise there.
Here comes the guard.
I cannot hear him.
Guard's like, whatever.
All right, can you try to send him a message that will pass this matter and call him back up that you're emailing? So he'll see that on the
They
screen.
have a remote.
Maybe, hold on. Oh, okay, gotcha.
They're sending him a message. He's shaking his head.
I can't even tell if he can hear me. It's just, we have no sound.
Guard's like, well, I don't know. It's not working. I pushed the remote button.
Mr. Johnson, if you can hear me, just wave your hand. Yeah, he can't hear me. All right.
I'll try to turn it off and on
You're
again.
going to email them? All right. I'm going to pass it.
Okay.
Sorry, Mr.
Court
Johnson.
does call the case People versus Joanne Crawford.
Good morning, Judge Alan Cooper for Joanne Crawford.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Your Honor, I've discussed the matter with my client. He's agreeable to waiving the preliminary exam.
Where's your name, sir?
Joanne Crawford.
And you're going to waive your preliminary examination?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants found over to circuit court on the 2 counts.
Your Honor, may I address the issue of bonds again?
Well, let me do the arraignment and then I'll do that. Do you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
And at this time, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. I will set circuit court pretrial for
March 2nd at 1:30 with Judge moved.
March 2nd, 2026, 1:30 before Judge Hamoud. Yes, that's the bond.
Yes, Judge. I made this request last week as well. My client, unfortunately, he had a difficult time with his employment over the past 2 or 3 years. He was injured. However, he has been seeking employment. He actually does have a job offer letter substantiating that he's got a job waiting for him. Now, that letter is from a company called Real Truck, indicating that his start date was actually supposed to be the day before yesterday. But he thinks that if he follows up with him, he might still be able to get this job underway, which is obviously significant because the whole crux of this case is to get some kind of payment schedule. If he's not working, then he can't work out a payment schedule with the prosecutor. So
this is true.
I understand that there's been some non-payment over the past year or so. That's because he has been unemployed, but now he actually does have employment. He's trying to properly put this matter behind him. So I think the fact that he actually does have a written job offer is good cause to reduce the bond. I would like a personal bond because that's all he can afford. The family is in court. There's no risk of flight. He's got 5 brothers and sisters. All of them have tried to talk and try to compile some, even the 25%. None of the family members can come up with this. So it's going to be up to Mr. Crawford to actually try to get payments to work something out ultimately when he deals with this felony child support case. So because he's got this job waiting for him, it's solid, it's confirmed, it's in writing. I would just ask that the bond be reduced to a personal bond, and let's deal with the matter at circuit court.
Are you saying the $25,000 that was listed on the complaint was only non-payment for a year?
Yes.
Is that what you're indicating, counsel?
Your Honor, I didn't do all the math on it. I think his support was set at about $1,200 or $1,500 a month.
Yes.
And I'm not sure if it was for 1 year. I think it was over a period of 2 years, or maybe a year and a half or so.
I mean, the difficulty is that the statute, I mean, I hear your argument, but the statute very clearly dictates 25%. I'm not sure that a job offer, and this court wouldn't find that a job offer in and of itself is going to constitute good cause. But
otherwise than what you're doing, then you're looking at punishing him for basically what he's actually charged with.
I'm not punishing him. He didn't pay for his child, so don't put it on me.
Well, in effect,
if you don't pay for your children, this is what happens. This is the punishment for doing that. So don't put it on the court or anybody else. The legislature made the statute. It says 25%. I'm not punishing him for anything. If he doesn't meet the standard of good cause, he doesn't meet the standard of good cause, counsel. Do I have a response from the people?
Yes, Your Honor. I would agree with you. We would ask that you deny modification of the bond specifically to a PR bond. Again, as stated last week and as stated today, lack of payments, promise to pay, to me, in my opinion, is not good cause to modify the bond. While the defendant was out and free and not under, of course, not incarcerated, he had the opportunity to pay. The amount that accrued is now at $32,000, over $32,000, and that was over a few years. So we have no guarantee that just releasing him and him seeking a possible employment opportunity will guarantee payment. And for those reasons, Your Honor, we would ask that you deny modifying the bond today. Thank you.
This is nothing different than I heard the last time that he was here. And quite frankly, the court in it would be of rights to up his bond because the amount is now higher than it was in the complaint. But I'm not going to do that. I'm going to leave it where it is at this point. But I'm not going to find that there's any good cause. Once again, motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls case People versus Stephen Gavan.
Michael Gaddy, Assistant Public Defender for Mr. Gavan, Your Honor.
Here. Ron.
You want to state your name? You want to state your name?
Mr. Dron, state your name. Oh, I see.
He's refusing at this time.
He's refusing? Okay, but
yes, sir.
That is Mr. Javon, according to your records. Officer.
Your Honor, I think this is a competency review. I didn't receive any kind of.
I didn't receive a report either.
I did try and see Mr. Gavan and he refused me yesterday.
He refused it. Okay.
Judge.
Yes.
Is this the case where we adjourned so we could do a casual and he's had me finding a number of months ago, but has refused to come out to court? Just trying to remember the case.
I believe that, yes, it is. He's not, the last opinion is he's not competent to stand trial, but he is at least present via here. I think the last time he wasn't coming up, we did not have any communication with him, but I would consider him to be present at these proceedings now, since he's appearing via tablet, although he doesn't want to say anything. So I'm going to, is there any other additional evidence regarding finding of competence?
There is, I don't have anything further, Judge.
Anything from the people?
No, Judge.
Court would find that the defendant at this time is incompetent to stand trial. I will sign an order to that effect.
I'll type that up and send it to the court.
Well, I have an order that was signed.
Thank you.
I'll set a competency review hearing for, give me 90.
May 14th.
May 14th, 2026, 9 a.m. Bond continue. Thank you. Court calls case People versus Derek Hunt.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Derek Hunt.
Get out the way. Come on, Mr. Hunt. Mr. Bird is just lingering in the aisle. Just.
Please state your name.
Derek Hunt. Oh.
Your name, sir?
Derek Hunt.
All right.
Your Honor, we're asking to adjourn this to continue a plea discussion.
Probable cause conference in this matter will be adjourned to March 12th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Nikita Griffin.
Good morning again, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Nikita Griffin. Mr. Griffin, please state your name.
Nikita Griffin.
Thank you.
I'm here. Your Honor, I believe Mr. Griffin would like to waive his right to a preliminary exam after a plea discussion. The offer he's interested in would require him to waive this.
Sir, is that correct that you want to waive your right to a preliminary exam?
Yes, it is.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution? You understand?
Yeah.
People also waive the right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on 2 counts. Mr. Deals.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
March 19th at 1:30 with Judge Slay.
March 19, 2026, 1:30 before Judge Slay. Mr. Giles, anything regarding bond you want to accuse me of keeping him in?
I don't believe so. I think bond is set.
I know that was unfair. Is there anything regarding bond, Mr. James?
No, thank you.
All right, thank you. Bond will continue. Thank you, sir.
Thank you.
Is that it for Attorney General or she got more? That's it? All right. Thank you, Madam Attorney General. Court calls the case of the people versus Ashley Albert. That's why it went sideways. Constantina was over there, but see, I didn't even see her.
Yeah,
It was Gaddy. Gaddy was blocking.
Yeah. It happens a lot, Judge. Christina Costantino appearing on behalf of Ashley Elber. I believe she is appearing via Zoom. Ms. Elber, can you please state your name for the...
Ashley Elber.
Oh, there she is. Okay. All right. You're seeking an adjournment.
Yes, Your Honor. I was just appointed to Ms. Elber's case late last night, so I do not have discovery. I also need to have an opportunity to meet with her and discuss her matter. So I would be asking for an adjournment of the probable cause conference.
Probable cause conference objection will be adjourned March 19th, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case of people versus Braisha Anderson.
Assistant Public Defender Jay Bellinger on behalf of Ms. Anderson on cases ending in 5640 and 5026, Your Honor. We're also aware of the bond violation this morning.
Yes, Your Honor. Brandon Bird on behalf of Braisha Anderson on the case ending in 5330.
And Ms. Anderson, can you please state your name for the record?
Braisha Anderson.
And Your Honor, as to
Bond
the
violation this morning.
PCCs on this matter, we would be asking for an adjournment. I have spoken with the prosecutor. He's looking for a mitigation on this,
How do you
which
like
I'm
that
happy
sign?
to draw up, but that will take a few weeks.
You have to unmute.
Here, Your Honor.
All right. So you want me to
I am Super
adjourn
T.
that
Thank you.
and the bond
22 months.
violation, or
Oh, gee.
Your Honor,
On the
after
jury.
speaking with our client, it's my understanding that she is willing to plead guilty to the violation this morning. We do have an explanation.
Better have an explanation if you violated bond the day of court.
adjourn to probable cause conferences then to, will the 5th be enough time for you to get done what you need to get done, or do you need the 12th?
I would need the 12th, Your Honor.
Adjourn these to March 12th, 2026, 9
I'm gonna come meet with you so we can.
As to bond, I guess, the court having accepted her plea guilty to the violation.
Respectfully, Your Honor, our client wasn't able to get in the house in which she was living. So her tether died. Am I correct?
Yeah. Our understanding is that she has a roommate, Your Honor. Her roommate locked her out of the house. Her phone was in the house. Her tether died. She wasn't able to get back into the house and charge it. She does apologize to the court for the violation. She really had no way to do it. As to the missed test, Your Honor, again, she didn't have a phone at the time. She couldn't call.
Did she not have the charger? Or
she did not have the charger that was in the home.
Did she go to community corrections?
She did not, Your Honor. She had no way to get there, and she otherwise would have called them. However, her phone was in the house. Is that correct as well? Okay.
Well, what actions did she take to try to get it charged?
I just tried to get back into the house, and I just tried to try to find it, try to have her give me the charger or throw it through the window or something, and she wouldn't let me in.
Where was the house was located? Where?
It was the one on Packer. It was the apartments on Packer.
It's a pretty tumultuous relationship with the roommate, Your Honor.
Okay, I get that part of it, but I guess what I don't understand, if she's on Packard, why she didn't just walk over to community corrections?
I honestly didn't even know I could have just come over and just said like, hey, I didn't have the charger. I really just didn't know that. I rather was trying to get it.
Well, where is the charger now?
Still in the house.
So if I were to let you out, where would you? Well, first of all, you didn't appear was one of the things. Why didn't she appear for the hearing?
Your Honor,
the last hearing, the jail did say that my client wouldn't come out to cell. Now, after speaking with Miss Anderson, Your Honor, she's been very polite to me. She has been very polite, and I believe we're able to work together now to get some of those issues handled. That's one of the reasons why we're trying to put in this mitigation report for mental health issues. My client does suffer from mental health issues, Your Honor, but she understands that she has to show up to court. She understands where she doesn't want to be at this time.
Okay, when she's locked out, where was she then? And when she was locked out, where was she?
I was on the passport.
What did you do when you were locked out of the house? You were still at the house?
No, I ended up going over to my godparents' in-laws. Ended up going over there and staying over there for a minute, and then going back to my apartment every day trying to get into the apartment. And that's where I got arrested.
Okay, so when you went to your godparents, did you ask them to give you a ride to community? I mean, I guess I'm not understanding.
I never thought to come up to community corrections because I have to call a number, right? You can't just come up. You have to call the number, and the number says your number or color, and then you come up. But without my phone, then without the charger, I just didn't do it. I never thought to just pop up and come up. I didn't think to do that. It just wasn't in my mind to do that. I get what you're saying, but I just really honestly didn't think to do it.
Response.
No objection to a release for treatment, but I do have concerns for this defendant's own well-being. On the new case, the 26 case, in that report, the defendant indicates she attempted to harm and kill herself using drugs. So I'm concerned that when you don't have testing and there's this prior history of attempts to use those drugs to commit self-harm, we might not see this defendant again if released on her own without any sort of supervision. So I think release to treatment would be good and appropriate, but otherwise I would ask.
Would you be okay with a release to treatment? Is that something you want us to?
Yeah, right.
Okay. Your Honor, after speaking with my client, it's my understanding that she herself would be okay with the release to treatment. So I'm happy to submit an order to the court.
All right. So what I will do is
I can submit it on your case too.
All right. I'm going to continue her bond at the amount it's at.
I'll get that done.
Signed once presented to me in order to release to treatment.
I'll include you on the email.
I'll also adjourn the sentencing on the violation to the March 12th date. So I'm not going to sentence her on that. I'm just going to leave everything where it is. We'll get the order. If she can get released to treatment, that'd be great. I think that might be the best thing.
Okay. Thank you very much.
Thank you. Thank you.
Okay. I'll be in touch. Okay.
All right. Thank you.
Thank you, ma'am.
Sweetheart.
Mr. Johnson. Yeah. There's recalls case people versus Avon Johnson.
Carolyn Foster Tucker on behalf of Avon Johnson, standing in for attorney of record Adrien.
Good morning, Johnson. Can you state your name?
Avon Johnson.
Okay, now we have you. Okay. You don't have any problem with Miss Foster Tucker appearing for your counsel of record?
No, Your Honor.
All right. Thank you, sir. All right.
And Your Honor, Mr. Drukas is seeking an adjournment. I believe they're close to a resolution.
Got it. All right. Probable cause conference will be adjourned then to March 5th, 2026, 9 a.m. We'll continue. All right.
Thank you, Your Honor.
All right. Thank you, Mr. Johnson.
Thank you.
Court calls the case of the people versus Harold Couch.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Couch, who now stands to my right. Mr. Couch, if you could state your name for the record.
Harold C. Couch, Jr. He's waiving.
That's correct statement, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, I am.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution?
Yes, I do.
People also waive their right?
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Hall.
Your Honor, we'd waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
April 15th at 1:30 with Judge Conlon.
April 15, 2026, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Edna Germa.
Please, Honorable Court, Brandenburg, on behalf of Edna Germa. Ms. Germa, please state your full name for the record.
Excuse me, Edna Joy Germa.
Thank you. What are we doing?
Respectfully, Your Honor, I just got appointed to this matter. We're gonna ask for.
And you're not ready? No, go ahead. I'm sorry. My bad.
We're gonna ask for adjournment on this matter.
All right.
I'm gonna have to turn in my green sheet.
You don't have it?
I don't.
What have you been doing? Besides, never mind.
Don't do me like that. Don't do me like that.
Probable cause conference. I'll just adjourn it out in 2 weeks, let you get caught up and do that. Okay, Ms. Germa?
Gotcha.
March 5th, 2026, 90.
And permission to address bond, Your Honor.
Yes.
Respectfully, my client did have she did drop dirty. She doesn't want to make any excuses why, but she wants to move forward and knows that she can move forward. She's 61 years old. Been through a lot in her life, but she is trying to make things right. She has a Stop the Gun Violence outreach program that she's preparing for in June that's sponsored by the Ypsilanti, sponsored by the city of Ypsilanti, in which she's the administrator for and makes a lot of things happen for that. She understands that she needs to work at it. She does have meds that she's not receiving right now. She does have a therapist that she goes to when she's out there for some mental conditions that she suffers from. And she did put in a referral for Down Farms and mental health, in which she told me that
for Down Farms and mental health too.
No.
Go ahead.
Okay. The Washington mental people gave me an intake
for Down Farms.
Yes, sir, for the outpatients on Gulfside.
All right. So respectfully, Your Honor, we're just asking that is why is an honorable court give Ms. Germa a chance. No, give her a second.
Wise nor honorable.
Wise.
Go ahead.
give Ms. Germa a second opportunity, and she will prove to this court that she can abide all bond conditions.
Yes, sir.
Any response from the people?
Judge, I believe that you changed your bonds because of contingency use.
Yeah.
And what she's doing in the jail is admirable, and I think that she can get started in the process now.
What I'm going to do, just listen to it. I'm going to deny your request. However, I will sign, if I have not, a release to treatment. Okay. What's wrong, Ms. Germa?
This will be our 5th event.
I know.
And it's in honor of my nephew who was killed on Thanksgiving in 2021, and all gun violence families, survivors, and the community.
But hold it. Maybe you're not hearing what I'm saying.
Shut up. I'm gonna shut up.
No, you can talk to me. I don't have a problem with that. The release to treatment I'm not saying that it has to be inpatient treatment. I'm saying she can be, but she's going to have to be released to treatment. It sounds to me like you started that process. So if we can get that all worked out, I'm not going to have a problem with that, because that's really what you need. And although you're trying your best, you can't do that on your own. That's just the reality. And you know that as well as I. Okay?
Okay.
So, counsel, if you get me a release of treatment order, I'll sign it.
All right, thank you. Thank you, Your Honor.
All right. And for her, it can be inpatient or outpatient treatment, but I want something structured around her before I'm even going to consider releasing her for whatever reason.
All right, sounds good, Your Honor. Thank you.
Thank you. Court does call the case, People versus Mario Taylor.
And good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martel, P85051, on behalf of Mario Taylor, who joins us via Zoom. Mr. Taylor, please state your name for the record.
Mario Taylor. Good morning, Mr. Simpson.
Thank you. All right, what are we doing?
Judge, discovery is complete. We're asking for a preliminary examination date. Please and thank you.
Date set for is what? Pardon, sir. People have their witnesses available March 3rd.
Yes, Your Honor.
Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before
Judge Braisha.
Judge Braisha.
Your Honor, I don't know if it's possible. Would it be okay to have it set before Judge Perry? The only reason I'm asking is because co-defendants have exams set for the same date before Judge Perry. It's the same witnesses.
Co-defendants have?
Yes.
All right. If co-defendants are set, there's no reason for me to set it before two different judges. I'll set this before Judge Perry.
Thank you.
Bond will continue.
Thank you, Judge.
Thank you. Court case, People versus Ernest Gardner.
Sherilyn Foster Tucker on behalf of Ernest Gardner.
I did, yeah. Your name, sir?
Ernest Gardner.
All right, what are we doing?
Your Honor, we're requesting a preliminary exam. Discovery is complete to my knowledge.
People have witnesses available the 3rd. Preliminary examination in person, March 3rd, 2026, 9 a.m. This will be before Judge Freshour.
Thank you.
Council should be aware, although it won't matter for me, there was a communication sent from the defendant to the court, which the court has a copy of. I don't know if you have copies.
I don't.
All right. Thank you.
Thank
you. Continue. Court calls case People versus Jacob Grammatico.
People, Your Honor.
And good morning, Your Honor. Joseph Hall, appearing for on behalf of Mr. Grammatico, who currently stands to my right. Mr. Grammatico, if you could state your name for the record.
Jacob Grammatico.
Thank you.
And Your Honor, at this time, people are unable to see this account. One would ask the court to remand down to district court on count 2.
No objection.
Count 1, you're moving to dismiss.
That's correct statement, Judge.
All right, dismiss. I'll continue as not guilty plea. As to count 2, I'll set a pretrial in that matter.
March 18th at 9 a.m.
March 18th, 2026, 9 a.m. That is before me. Do you believe? Well, now, this wouldn't go to the 18th. This is a DV.
I apologize. March 2nd. At 1 p.m.
March 2nd, 2026, 9 a.m. before me. Thank you.
Oh, at 9 a.m.? Okay, I can.
Yes.
I can make.
All right, I'm sorry, 1 p.m.
1 p.m., even better.
Thank you.
So that I could make you happy, Mr. Hall.
I knew you were trying, Judge.
Yes, I was. All right, thank you.
Thank you very much, Your Honor.
Yes.
Thanks, Your Honor.
Court calls the cases of the People versus Kawandake, yeah. Thomas.
And Sherilyn Foster Tucker on behalf of Ms. Thomas in the cases ending in 1211 and 5653.
And Michael Gaddy, Assistant Public Defender in the cases in 1945 and 5565, Judge.
All right. Okay. Your name, ma'am?
Hello, I am Kiwana Place, Cynthia Rose Thomas. Good morning, Your Honor.
All right, what are we doing?
Your Honor, Ms. Thomas understands that she has an absolute right to a preliminary examination. She wishes to waive that right and seek.
We're going to bail. Hang on. Josh says we have to go here.
Now, do you know 1030 South Holmes Street?
Yeah.
How do you know that address?
Where I live.
Were you living there on December 20th of 2025?
Yeah.
And was Adrien there with you that day?
Yeah.
Now,
What is
at
this, Josh?
some point that day, did you end up going out to a dicker and deal with Adrien?
Yeah.
Dicker and Deal?
At some point there, did you end up speaking with police?
Is that the name of a company?
That's the part I don't remember. I know I talked to them, I just don't remember that part.
Okay.
Like who I talked to, what I said.
But you remember just speaking to police in general while you were there at dicker and deal? Now, at some point that day on December 20th, 2025, well, actually, let me back up. Do you own a firearm?
Yeah, I already did. I asked the police to destroy it, so I wouldn't have to use it on myself.
What type of gun was it?
A 22
Was it a revolver or semi-automatic?
revolver.
I'd like to approach what's been marked as People's Proposed Exhibit 4. May, Your Honor?
Yes.
Ms. Crawford, do you recognize what's in this photograph?
Yeah,
How do you recognize that?
that's my gun.
Does that appear to accurately reflect your gun that day?
Yeah.
People would seek to admit People's Proposed Exhibit 4 into evidence this time.
Give me a drink.
Preserve the issue, Your Honor, yes, I would object to grounds of lack of foundation. As she described, she claimed the gun was destroyed, so at this point.
You said that I didn't hear what you said. She described what?
She claimed that the gun was destroyed, or she was requesting the gun to be destroyed, so respectfully, lack of
I mean,
foundation.
I think this was my gun.
Ma'am, you can't talk over his objection.
Your Honor, that objection does not have any bearing on the foundation of this.
Yeah, I was trying to understand how that connected to this. It doesn't have any connection. So the objection's overruled.
Thank you.
It's admitted.
I'm going to publish the report.
Yes.
At some point on December 20th, 2025, was that gun pressed into your face?
By myself, yeah.
We told him to turn that down.
Whoa.
Did it leave a mark?
When I put it against my cheek,
Okay, when the gun was pressed into your face that day, left a mark that day.
when I did that, yeah, and I took a picture.
And did you took a photograph? And did you also have a time and date stamp on that you sent to the police?
Yeah.
If I may approach what's been marked as People's Proposed Exhibit 3.
May.
Do you recognize the current exhibit?
Yeah.
How do you recognize it?
What do you mean, how?
Well, what is in the photograph that you recognize?
Myself?
Is this something that you sent to the police?
Yeah.
Does it appear to accurately reflect what you sent to the police?
Yeah, it was the timestamp.
Yes. And does that photograph appear to accurately reflect the mark that the gun left on you that day?
When I put it against my face, yeah.
So that's the mark the gun left that day, correct? I believe that there's sufficient foundation here for admission of People's Proposed 3.
To the objection.
Yes, Your Honor, lack of foundation, make it.
People's 3 is admitted.
Thank you. Can I publish to the court this time?
Yes.
Thank you. Ms. Crawford, you've said a couple times now that you were the one who put the gun into your face, but isn't it true that you told the police several times on December 20th, 2025, that it was Mr. Johnson who put the gun in your face?
I don't recall.
You don't recall? Okay. Well, would looking at a video of your interaction with police that day help refresh your memory as to what you said?
As to what I said?
Yes.
I'm not sure.
Okay. Would you like to try?
I don't know if that will aggravate my PTSD or not, because the whole day was
very traumatic for me.
Well, ma'am, I'm not asking about how it's going to affect your PTSD. Do you believe that it will help your memory as to what you told police that day? Not about what you're claiming happened, but what you told police on December 20th.
I don't think it would help my memory because I don't even remember getting home that day.
Okay. So
you don't remember doing what?
I don't remember even getting home that day. I don't even know how I got home, if I drove home, if someone brought me home. I don't remember talking to the police that day.
But you remember putting a gun to your own face?
Yeah.
Okay, and
that was before.
Before what?
Before we went to the gun shop.
Okay, and you
So you know you
remember
went to the
talking
gun
to the police?
Briefly.
Okay.
But I didn't even remember the police officer. Like a police officer told me that she was there and I don't remember her or talking to her.
Okay. So you don't know if it will refresh your recollection or not?
No, I don't.
Okay. She doesn't know if it will refresh your recollection or not.
Go ahead, Short. Blackbirder, 20 months OG. Thank you very much. Appreciate your support. Okay, I think this is although the facts of the case are quite troubling, this seems to be a false report issue. And she has a lot of excuses. Let's see. There are ways to get
Ms.
around
Crawford, at one point, did you say that you had done this on purpose to keep Adrien Johnson safe in jail?
Not that I recall.
You don't recall?
No.
You don't recall saying that at the last court hearing?
To keep him safe or to keep myself safe?
To keep him safe.
I don't recall.
Okay.
She said it the
I know
last.
that we were both being threatened.
Thank you. Now, have you told police that Mr. Johnson has threatened you in the past?
I don't recall what I told the police.
That day or ever?
Ever? What do you mean by ever?
You've talked to police more than once about Mr. Johnson, correct?
Yeah.
Have you ever told the police of Lansing that he has threatened your life in the past?
The city of Lansing?
Lansing Police Department. Have you told the Lansing Police Department that that man has threatened your life before?
Threatened? I don't recall if I said threatened.
Okay. Have you told Lansing Police Department that he has hurt you in the past, physically?
Yeah.
Was that true?
Yeah.
Has he threatened you before?
I don't recall. I wouldn't say threats.
Well, what springs to mind when I say threatened you?
Your Honor, I'm just going to object at this point on the grounds that these questions are overbroad. They're too vague. They open
What is
up.
vague about threat?
Well, Your Honor, but what's the time frame? What would be the timeline? Like, are we talking decades? Are we, we're getting into other alleged acts here already? The prosecutor has filed this petition notice. I don't know where this line of
I
questioning.
don't think that this information, well, I don't know why he's soliciting. I'm assuming that he's trying to gauge her credibility at this point.
I am.
Not anything against your client. It's not, I don't think that's what it's being used for. That's not what the court's taking it for, at least. The other thing is, I do agree that maybe it would have been helpful to narrow in a timeline, but under the circumstances where it appears we might have a hostile witness, I don't think that I can grant your objection. I'm going to have to give him some leeway. The other issue is, I think it's very clear what, well, maybe it's not clear. I think you have a point where the vagueness of threat means, his next question was, when I say threat, what do you mean? So I think we're narrowing that down now. So I'll deny your objection at this time.
Thank you, Your Honor.
You can proceed, counsel.
Your Honor, I do need.
There's no question on the, do you need a break?
I would like him to be more specific. That's why I can't answer.
Well, he's asking you to actually explain, so that doesn't, it allows you to explain what that word means to you.
So my question was, has he threatened you before? And you said you wouldn't call it a threat. So what wouldn't you call a threat? What are you talking about when you're hurt?
Like I'm going to hurt you, or like has he physically hurt? So usually whenever he was in active addiction or on his not off his medication, he would just hurt me. He wouldn't threaten to hurt me. I guess that's why.
Okay.
Why is she so?
I don't recall, but he could have too. Like, I mean, I don't, when those instances happened and I was in trauma.
Okay, so let me just get clarification. So what you're saying is when he asked you if you've been threatened by the defendant, you're saying if he's hurt you before without giving you pre-warning, you don't consider that a threat.
Correct.
But if he said, I'm gonna hurt you, that's what you're considering a threat.
Yeah.
Okay, thank you.
Okay. Why did you end up going to Dicker and Deal that day?
Because when I was asking Adrien how to use my firearm, it was jamming.
Well, her comment, I believe, is being phrased as a question, so I guess technically it's not hearsay, Your Honor, but just in terms of her testifying about her own statements, it would be potentially hearsay, but my apologies. Apparently she was asking a question. Is that how you were phrasing it?
So when she was asking him about her firearm, it was jamming.
Okay. Well, all right, I will just object on the grounds it calls for potentially hearsay in terms of her response and her comments to the allegedly to Mr. Johnson. Thank you.
Did you want to respond? I don't either. She's testifying about her own statements.
She described why she went there. It's literally back on the list.
So the objections are ruled.
So, Ms. Crawford, can you please say again, I know you were cut off in the middle of that, why you ended up going to Dicker and Deal that day?
I had got what wasn't the first, it was right before all this was taking place, I had gotten some unknown callers related to a case where I'm a lead witness in Berrien County, and they were threatening my family. And that's the reason I purchased the firearm in April, because I was getting witness intimidation calls. And I have only owned a 9mm in the past, so I wasn't really that familiar with this gun because I got on sale online. And I didn't really know how to properly use it. So I was asking Adrien to assist me, because when I was trying to load it, it wasn't working. And I was worried that the guys, because they said they knew where I lived and they knew what car I drive, that they were going to come shoot me, and I want to be able to defend myself. Even though Adrien was like, I'll defend us, I just thought, what if he wasn't there? Like, how would I not be able to defend myself against these guys from Ben Harper? Like, how would I not?
So why did you end up going to Dicker and Deal that day?
Because I wanted the gun fixed.
Okay, what was wrong with the gun?
It wasn't, when I was loading it, it wasn't loading properly.
You said before you were caught the first time that you were talking to Adrien about because it was jamming.
Yeah.
Okay. So when did the gun jam that day?
I don't know how you say it properly.
You said jam. When did the gun jam that day?
Well, he was outside when it jammed.
Okay, when did it jam that day?
When I put it against my face.
Okay, so your testimony is you put it against your face, pulled the trigger, and it jammed. And then you talked to Adrien about how to use it correctly.
No, I talked to Adrien how to load it before I did it.
Okay, but you said the first time that you were talking to him because it had jammed. So did it jam?
Sorry, you're confusing me. Can you repeat that?
Did it
without
jam?
Going back to back, because I still have memory recall issues of that day from the traumaticness of it.
So you have difficulty remembering what happened that day?
I have difficulty remembering certain parts of it. My doctor said it's called disassociation.
Okay, so did you talk to Adrien about how to properly use the gun before or after it jammed?
Before.
Before it jammed. So you were just talking about to load the gun in general.
Yeah.
Okay, so when I first asked why you went to Dicker and Deal, you said you were talking to Adrien because the gun was jamming, about how to properly use it.
No, I
So-
said I want to pick on deal because it was jammy. I wanted to fit.
The transcript will show what the testimony was.
Okay, well,
But-
you're confusing me. You're repeating the questions and you're changing them, and I can't, like, I'm gonna need a break. Because you're just.
You can have a break.
Thank you.
Because of your prior request, do you need the break here or do you need it any other way?
I'm coming here for now.
Okay.
If you need.
Give her a couple minutes.
Give her a couple minutes. Okay, I think this this woman is gonna walk herself into a perjury charge. Honestly. Can you move yourselves up to the corner? Yeah, I can do this. Hang on a sec. Sorry, I've been given, rightfully or wrongfully, access to a Google account to manage for an organization, and I think I just messed up their whole account. Yeah, let me move me. Just one second. This is the woman that came in with her own writer when she's like, I'm here to testify, and here's my list of demands. I need Evian water, cooled, 62 degrees, no warmer, or lukewarm, 62 degrees, no warmer, no colder. I need to have a seated cushion, 2 people to fan me, one on my left, one on my right. Questions can only be a maximum of 7 words long. She had, like, I don't know what they were. I was making some of those up. But she had this huge list of, if I testify, this is this. And she's like, no. You get subpoenaed. You sit your butt up there and you answer the questions. If you need a break, you get a break. She's got a break. So, yeah, this is a crazy witness. As far as crazy things we see in court. I'm not saying that she mentally is unstable. That may or may not be the case. I have no knowledge about that. You can make your own call. She did mention PTSD regarding this incident. It sounds like the state is prosecuting the gentleman at the very bottom corner of the screen. And she is either backtracking or walking a fine line somewhere in the middle and not wanting to be one side or the other. No, not doing Colin Gray. There's a lot, and I realize there's some big cases. The Scott case down in South Carolina or Georgia, I can't remember. Colin Gray is going on right now. We're picking up Corey Richins, which starts on Monday, which is why we're not doing any of these other trials. There's the dump the wife's body in a tank trial going on. We've got a lot of things going on. We can only really cover one effectively at a time, and this is one we've put a lot of time and effort and coordination into, so we're sticking with our schedule. That's why. Not that there's anything against some of these cases. Some of them are great cases, and if you want to follow it, please, by all means. We just can only do one at a time. Felicia Lemaster, sorry I'm late. What is this trial we have right now? Right now we're court hopping while we wait for our trial with Judge Stephanie Boyd to start this afternoon at 2:30. I think that's Eastern time. So after lunch, we're going to return with Judge Boyd for day 2 of a murder trial that a man was charged with shooting up a drug house some 24 years ago and then fleeing to Mexico. He just got extradited 2 years ago and is now facing a single murder charge. Apparently went in with a shotgun, according to the state, and shot 3 people, one of them being a child who was just lightly wounded, almost didn't need treatment type wounded. It was just bird shot that painful, dangerous, but not seriously injured. A woman who was seriously injured was shot twice, and then a man who was shot and killed. Obviously, that's where the murder charge stems from. So, let's see. I've got this, I'm in a, an access loop. The previous person who had control over this account that I was just given access to, had set up the verification as his phone number and his email. And without his assistance, I was able to change the verification number to my phone number. But now I can't change his email to my email. So I'm like stuck in the middle. I can't get a pass key without using his email, and he can't get the, yeah. So I think I'm like broken everything. But police's question was what this trial is about. I believe this is a gentleman charged with threats of some sort. I think it is domestic in nature. These two appear to have a relationship of some sort that might have involved drug use. A gun was involved. This woman at one point threatened and set or made an allegation that the gentleman in the bottom left-hand corner had threatened her with a gun that she used to own, even taking a picture of the spot on her face where the barrel was pressed against her face. Now she says she did it herself and that she gave the gun to the police and asked her to destroy it for her safety. But she has come to court. This is the second time we've seen her. She came to court last time with a list of demands as what she would allow as a witness. Basically, complete diva. And now we see her trying to work that system. Now she gets a break because the questions are too much for her. They're confusing. Sorry, I'm still trying to access this system. I might have to take a picture of a QR code, text it to the guy who last had control, say scan it, and say, yes, it's me. I know that defeats the security purpose, but all right, you remember now this was a wild one. She just gets a couple minutes to relax. In the meantime, the prosecutor has, looks like, checked the transcript, gone back to see what she said last time under oath, which she also claims to not remember. It's gonna be a fun one. Oh, they have a child. Wow, that complicates things. Having worked in the sort of the television industry loosely, and been familiar with concerts and traveling professionals that come to town on contract and generally have a writer of some sort. What's that? Something came in the mail. I don't know what it is. Might belong to one of the kids. It's clothing. My grandson calls it an appage, a package. Yes, no mail for me. Okay, we're back. Let's see how this goes. I opened mail. It's had my name on it. but the Amazon account does. So just waiting for the prosecutor now. The judge is back. I'm trying not to talk a lot today because I guess a feature of this this cold is I'm just out of breath always. I don't feel like it, but as soon as I talk, I'm just like sweating and gasping for air at the end.
Okay, back on the record. Proceed.
Has Adrien ever handled that firearm before?
Yeah.
You also said that Adrien says, quote, "I'll defend us," right? Meaning the two of you?
Yeah.
Was he referencing that gun and talking about defending you two?
He said if we had to, if they had guns.
Now, did you send a video to the police of Mr. Johnson holding that gun?
Yeah.
Your Honor, I'd like to approach with what's been marked as People's Proposed Exhibit 10. It's just a frozen image of it early on.
No problem.
If I may?
Yeah.
Do you recognize what's on the computer marked as People's Proposed Exhibit 10?
That's not the photo I sent.
No. It's a screenshot from a still from People's 10. People's 10 is a video.
Oh, that's not that one with the timestamp on it and the date.
Correct. Don't worry. That will be handled in a while. But does that appear to accurately reflect the video you sent to the police?
Yes.
Your Honor, at this time, people seek to admit People's Proposed Exhibit 10 as evidence.
The objection.
Yes, Your Honor, like a foundation. Like
It was sent admitted.
Now, you mentioned a timestamp. When was that video from?
December 15th.
Okay, so it wasn't from the date we've been talking about, December 20th. It was from 5 days early. Is that right? Your Honor, at this time, I would seek to publish People's Exhibit 10.
Yes, I just don't know if it's going to work with that cord in here. You might have to log into Zoom.
Oh, okay.
If he logs into Zoom, we'll definitely get to see it. I'm hoping that's the case.
Have there been technology issues since the last time I was here?
I don't think that's ever, since I've been in here, I don't think that cord has ever worked. You can attempt if you think it'll work.
That's last time I did. It's been a minute, but
Whatever, sir. You're like 14. No time has elapsed. This guy's a young prosecutor. Have there been technology issues since last time I was here?
Start share because the speaker is not allowed.
nope, weird. Okay, I'll log into the Zoom.
Yes.
I don't know what it's all about.
Judge tells him, doesn't work. You can try. Oh, yeah, I know what I'm doing. Oh, it doesn't work. Okay. Judge was right. She's like, it's my courtroom. I'm here every day. The cord never works. We just keep it there for show. Could be walking pneumonia. It's not. I don't have any wheezing or anything in my lungs. It's just a cold. Mrs. R.A. had it. My son had it first. We usually get stuff from my oldest son.
Suicidal. He couldn't help me. I couldn't die, Adrien.
Whoa. She might need more of a break.
And then I sent the request for the chair.
I just gave it to you. Did you need a moment, ma'am?
We just took a moment. Concept warning. This appears to be the defendant. I'm concerned with what he's holding. This is a video they probably recovered from someone's phone based on the orientation and the narrow view. She does seem to be faced with a reality that she either does not want to admit or does not want to have happen. And all her efforts to thwart the system from reaching this conclusion have been in vain thus far. And now, with an emotional outburst in court, it might be a last-ditch effort. She's not on trial. I mean, she might be eventually if she commits perjury, but she is not the one on trial. I don't know.
May I take an anxiety pill, Your Honor?
Yeah, do you need to step off for that?
My purse.
You can step off.
She's taking an anxiety pill. I would be a little concerned exactly what the pill was, which might... Some medication, by its side effect, not saying it's anything illicit, but by its side effect might make her not suitable to be a witness if it has certain side effects. Welsh Lady Reads, member for 26 months, OG. Always a proud member of RA in this chat. You all feel like home. Whenever I go, I always come home. Now, where's my cup of tea? Welsh Lady, I hope you're feeling better. I hope you're feeling great. Good to have you here. Your picture looks amazing. Anxiety pill doesn't work like this unless it's a placebo effect. It's a sugar tablet. Oh, they don't start working for 45 minutes. I think this is in front of just the judge. I don't think we have a jury here. I think the judge would be more cognizant of the jury's time if those delays were taking forever. I don't know what we're doing staring at this image with the prosecutor not talking. Clearly, he's got the share set up. For those of you that are counting, that was sneeze number 18 for the morning. Yes, that's 18 sneezes, possibly the most I've ever sneezed in my life. Brad, are you going to keep track of sneezes? I commit to do it off audio and preferably off video as well. Anxiety meds give me nightmares. A serious enough side effect, I guess they are. Red Pen, this sounds like the situation where the victim may have recanted or wants to change their story, is no longer willing to go along, but either stop short of refusing to cooperate or just did enough that the prosecution is trying to proceed. So now she's good.
The court's ready, Your Honor. Thank you. This is Pickles 10. I think it should work with sound.
You put share sound when you did it?
Okay, we have this is a revolver. It appears to be a revolver. We've heard it's a 22 caliber revolver. You have to share.
Oh, I see. Share sound.
There you go. Content warning here.
Who you at in the store, wherever?
Right, so starting from the beginning.
What you doing? Where you at? Who you at in the store? Wherever this nigga show up at, I'm letting that nigga have it. Whoa. And y'all can come and bring your ass.
So that's the end of Pickles 10. That was from, you said December 15th? And that's your gun in his hand, correct?
Yes. He was talking about the people that were threatened us.
Well, that happened.
Has he called you while this case has been going on from jail?
From Ingham County Jail, no.
Is your phone number 269?
867-5309.
If I could retrieve people's 7?
Yes. I've never picked up if he called. I've never talked to him at the jail.
Do you see your number in that list of numbers called for people 7?
They have recorded calls, ma'am. If you say you've never picked up, you better.
Yeah, and it says that what didn't connect.
Is there more than once?
It says it, yeah, it says it didn't connect, so I didn't ever, never saw a call from there.
But the second from the bottom. Second one from the bottom. Is that your phone number?
Yeah, it says didn't connect.
Where does it say didn't connect again?
It says it was charged 0, caller party hung up, called party hung up.
And do you see that there where it says 14 minutes and 13 seconds long?
Yeah, where is this from though? The Ingham County Jail or the City County Jail?
Ma'am, has he called you from jail while this case has been going on?
From the Ingham County Jail, no.
Has he called you from the City County Jail?
Yes, he did call me once from the city jail.
So you're still saying, despite this in front of you, you did not talk to him while he was in the Ingham County Jail?
Not that I recall, no. I called the Ingham County Jail and they said they had no calls to me from there.
Ma'am, this has already been admitted as a record of the calls he made from the Ingham County Jail, showing that he has called you many times and has spoken with you. For the first one was 14 minutes and 13 seconds on December 21st. Then on December 22nd, he spoke to you for 7 minutes, 39 seconds. You're still saying you haven't spoken to him from jail.
That was the city jail. It had to have been because I didn't get any calls from the Ingham County Jail.
I can return this to the court.
Okay. Like I say, I can't be sure.
Okay, so you're not sure if he called you from the Ingham County Jail?
Just by what the officer told me.
Nope, I'm not asking about what the officer told you. Do you recall talking with him more than once while he was in jail for this case?
I only recall talking to him once. The other time he could talk to my son.
Okay. Now, you've said a few times now that you cannot remember what you told police at Dicker and Dio on December 20th, but just that you talked with them. Is that right?
Yes, I don't even remember getting home that day.
Okay. I'd like to approach what's been marked as People's Proposed Exhibit 9. Let's pause at the 5-minute mark.
It's a video
Crawford,
of this courtroom.
Is that you?
Yeah.
Is that you at Dicker and Dio?
Oh, I thought it was this courtroom. It looked like the lights were the same.
So,
You don't think so?
no. That looks like a locker room.
Is there a date and time at the top right?
Yeah,
Could you please say what that date and time is?
12/20, 1300 hours, 9 minutes, 54 seconds.
Thank you. Your Honor, at this time, the people would seek to admit People's Proposed Exhibit 9 under MRE 803, subsection 5, recorded recollection. As the witnesses testified, she cannot remember what she said that day. Therefore, the rules against hearsay do not apply to those videos.
Sorry.
Thank you, Your Honor. No objection, grounds of lack of foundation. Thank you.
Okay, I think the witness is being very clear that she doesn't have any recollection. Your exhibit is admitted.
Go ahead and
Thank
play
you.
it. Roll tape. Wow. The state is doing the questioning. Yes.
And permission to publish?
Yes.
Okay.
And I'm starting from the 2-minute, 32-second mark.
Body one camera here.
Is there supposed to be volume? Okay.
That's supposed to be moving.
There's sometimes a lag.
Come on, let me stop the chain and try again. I know my computer's had problems with the internet access for that.
No, there's definitely a lag in here. Especially, I don't know if it's when we go through the Polycom that way versus the cord. The cord never works in here, and I don't know why.
Have you shared your audio?
Can I have a brief moment?
Take your time.
It's my tech issue.
It's my tech issue. It's not the cord, whatever it is. Britta says 1, 2, 3, not it. Looks like her in a police station, probably making a statement. She's walked herself into this now. Her prior statement that she made to police, the original complaint, back before she didn't recall anything, is admissible as evidence. It avoids the hearsay exception because she has no recollection now, thinking that that was going to help her by not remembering what she said before. Now they say, okay, since you don't remember, we can just play the previous tape. Now she doesn't get to, now she doesn't get to have any say in that. It's a sneaky procedural move that the defense tried to block with a foundational objection, but the judge said, nope, this is pretty clear, cut and dry textbook. It's admissible if you can get the audio to work. Judge did call her a hostile witness already. To her face, basically.
She actually appeared to be with the video player.
Use VLC.
Okay.
VLC will play anything. It's probably using Windows Media Player. The court is team time. It is.
Apologies. Try this again now.
Okay. Share audio.
Okay. She's sitting right here. Hello. I'm Officer Havard. Can you tell me what happened today?
That's my ex-husband. I've had a PPO on him since April, but he won't leave. And I've been trying to get the courage to call the police, but I'm always scared that he's gonna run right out. And I just keep telling him more and more and more, that I want him to leave. Will you please just let me leave? And he was like, no. And I've been recording him, when he chokes me, and then I say, why do you choke me? And he'll say, because you make me mad.
Okay.
And then
We got her sitting here, so you guys can
and
talk.
then I asked him again if he would leave today, and he pushed me in the bed, and he put the gun on my cheek, and he pulled the trigger, and it jammed. And then he told me that I have to take the gun to this place and get a different gun because that one doesn't work. And so he brought the gun in here and set it there, and then we walked outside. And I'm just so scared he's gonna get out. This is why I haven't been fun. I'm just scared. I don't know what to do.
Okay, it's okay.
I'm sorry.
She's saying this was a false complaint.
So you have recordings of
If
them?
you look, yes, and if you look up his record from Kalamazoo, he has lots of domestic violence calls for me, and choking and stuff like that for me. But they didn't work. Every single time he went to jail, he would get right out, and then they would have too many cases press charges or something. I don't know. I just feel like I've been trying to get away from him. I divorced him and then I got remarried and he was gone for a year, but he was on drugs. And then when he got clean again, then he came back for me and he said that he said he's gonna kill my husband that he made me divorce. He put a gun to my head and made me divorce him, and then I have some
divorce at gunpoint.
When did all this happen?
This just all happened now, but just in this past couple days, it's been the worst.
The gun thing happened today?
Yeah, like it was more like I took pictures when he was in the when he was in the bathroom. Just be careful with the gun because his fingerprints are all over, and if you touch it, then it might take them off.
Okay. So that's from the gun?
Yeah, it's a 22. He's still on here.
No, not anymore. Okay. How long did he have the gun pressed to your face?
Not very long because the jam is still here a little bit. Do you see?
Yeah, I see a little mark.
You can see if you check the gun that is jammed. Like you can't shoot it. Like that's the only reason why I'm alive.
Okay. Do you have an ID on you?
Sorry, guys, I'm just punching in.
Yeah.
From lunch. I'm not saying about it.
He's like, sorry, I'm just clocking in. Didn't mean to interrupt your.
Can you just check that he has a PPO? Like I am.
So there is a PPO against him, but it's not been served yet, so we have to serve him.
It is served. I did serve him.
So we don't have a record that he's been served.
I just texted it to his phone. You can ask him, does he know he has a PPO? And he'll tell you yes.
The issue is we have to have a record that it's been served, but he is going to go to jail today for domestic violence, okay? So we're going to serve him now so it gets officially served and that there's a record that it's been served and we can enforce that from now on. Okay? Do you have an ID on you?
I'm afraid that he's going to come back for me, a DV he can find out of.
I understand. But he's also got the PPO against you, okay?
Why is it DV when he tried to kill me? That's still DV.
It's felony domestic violence, but
it's not misdemeanor.
No,
like he
it's
probably
gonna be-
won't have a really $100 bond.
I can't tell you what the judge is going to do, so I don't know. But it's going to be a felony.
I'm scared.
You have the gun in the back room, untouched, so.
I thought I had my license on me. I don't know.
That's
He must
fine.
have took it out of here.
That's okay.
Here's my veteran card.
That's fine.
I know my license number by heart.
Is that legally how you spell your name?
Yes, and then I'm trying to find some videos from the other day. Here's when he was waving the gun at me.
That's from today?
Monday. And then
What's your middle name? How do you spell it?
JOYBRANDI. And then he was.
Your middle name is Joy?
Where you at in the store, wherever this nigga show up at, I'm letting that nigga have it or wherever the fuck he went. And y'all can come and bring your ass. What you doing? Where you at? Shoot the fuck out of Rome. I'ma shoot the shit out of Rome. Oh, shoot the fuck out of Rome.
Is Ron your...
Rome is my ex-husband.
Okay.
Rome, ROME.
Rome? All right. What's your date of birth?
7/26/79.
7/26/79? So, okay.
Good job, Ron.
Sorry about that.
And what is your current address?
Muting all this. All right. We might bail on this as it continues in this path.
Street.
I try my best to mute it, and then they put sub.
Is there an apartment number? Is it a house?
Apartment 105.
105. Okay. All right. And what's a good phone number for you?
867-5309. All right, let's jump back to Judge Simpson for a minute.
This is her first PCC, I believe. We'll be requesting a brief adjournment for further negotiations.
Mr. Fink.
House conference will be adjourned March 12, 2026, 9 a.m. Bond continued. Right. Court calls case People versus Grant. Mejia.
Your Honor, Michael Gaddy, Assistant Public Defender from, I think he calls it Duche. Your Honor, I have not had contact with Mr. Duche. I know he has profound medical issues. It's my understanding he missed court yesterday as well.
Yes, he did. Bench warrant release for defendant's failure to appear. Bond is set amount of $10,000 cash surety. That warrant will issue immediately.
Thank you.
Thank you. Calls case of the People versus Jacob Pike.
Here's Jacob. He's waited all morning for this.
Do you know what cases you have? You're always looking at me like it's some great mystery. There's private counsel?
Good morning, Your
So it's
Honor.
not your case. Then sit down. Jeez, oh, Pete. Go ahead, counsel.
Philip Kavanaugh, P number 59404, appearing for the defendant. I have filed an appearance in this matter, but not substitution of counsel, so I believe
that may be why.
Mr. Gotti is the public defender on this. But I was called in once again. I filed an appearance, but not a substitution. I would ask for an adjournment so that I could have a conversation with the prosecutor.
All right. I don't mind that. And if you guys can just make sure to accomplish a substitution so we get everything changed. So probable cause conference will be adjourned March 12, 2026, 9 a.m. or as your invite indicates.
Sir, when you do the substitution, this is Mike Getty. Have Delphia Simpson as the public defender, and we can put the bar number.
All right. Thank you.
May I ask who the prosecutor is, who I should contact?
Sure. I don't know who.
So, sir, you can reach out. This is Raymond Cook. I'll likely be handling the case. You can reach email.
Cookar, Washington.org.
Raymond Cook. Okay, thank you, Your Honor.
This is Jacob's
Thank
case.
you.
Here, so
I don't know how I knew that. I don't think I've ever sent you an email. I just knew how to do that. I'm smart. Court does call the case. People versus, and bond will continue on the fight matter. Court calls the case People versus Brittany Fisher.
Hannah Mackey on behalf of Mrs. Fisher, who should be on Zoom.
Yes. Ms. Fisher, can you state your name, please?
Yes, Brittany Fisher.
Thank you.
Yeah, and I would like to set this matter for exam, and all discovery is complete as far as we're aware.
That's an exam machine.
Gotta get the ball moving.
And would the people have their witnesses available on the 3rd?
Yes.
Preliminary examination in person, March 3rd, 2026, 9 a.m. That's before Judge Freshour.
Thank you. Miss Fisher will be in touch, okay?
Okay, thank you.
Bond continued. Thank you, ma'am. Court does call the case of the People versus Tyshawn White.
Charlotte Stefan on behalf of Mr. White. Your Honor, he's appearing via Zoom.
Yes, he is. Mr. White, can you state your name, please?
Tyshawn White.
All right. What are we? Thank you. What are we doing?
We're setting it for exam, Your Honor.
All right. Discovery is complete.
Yes, it is.
All right. Would the people have their witnesses available the 3rd? Preliminary examination in person. March 3rd, 2026, 9 a.m. before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. White. That's 11, finished basically right on time. Court's going to stand in brief recess. We'll come back, start the 11 o'clock block shortly. Court's in recess.
All right.
All right, we're going to jump back to the other court, see how if we've got through some of this testimony.
And next to it like he always does.
So he's yelling and screaming. At what point does he put the gun to your face?
After I said again that I didn't want to be with him, like I just kept saying, please, I don't want to be with you. I don't want to be with you. You please leave me. I said, please, like, please go to your mother's house. Please, like, I just want to have a good Christmas with my son. I don't want to keep having you do this. You keep choking, you keep doing all these horrible things. And he said, that's the least of your problems, Brandy. That's the least of your problems. I know you want to go back to your ex-husband. I know you don't love me. I can tell you don't love me. And then that's when he pushed me on the bed and he put the gun to my cheek right here and he pulled the trigger and then the gun jammed. And then, like, I was crying and everything, and I have pictures of it where it was more prominent, yeah. And
Interesting, she says the gun jams. It's a revolver. Revolvers function a little differently than a semi-automatic. Semi-autos will jam frequently. For a revolver to be jammed.
And then I can show you the videos that where it's been happening since Monday, where he's just been really.
Yeah, she's got videos of him waving a gun around and.
Rome is my ex-husband. That's why he's been so jealous. Okay. And that's the gun. And he always has it next to him when he watches TV. And then he's talking about if I'm with him, if you find me with him.
I was like, okay, I saw enough. Where is he?
Yeah, so we gotta say, because obviously we're getting a different story from him. We're good on our end. We can start in downtown if you want.
Yeah.
If you need anything from us.
No, if you guys want to start him down there, I'm going to finish up with her statement. I'll grab the gun and then meet you up there.
Okay. So you don't need anything.
Do you need the videos?
Okay.
Yeah, I'll get that in a second. Thank you, Lynn. Okay, so after the gun jammed, what happened after that?
After that, he was mad and he just kept trying to like mess with it and everything and it wouldn't work. And then he was like, oh hell no, this gun's broke. And then he said, you need to find me a gun shop or something because I need you to get a different gun or you need to get this fixed or something. And I was like, what do you mean? And then I'm like, I don't want to go anywhere. I want you to leave. And then I was just shaking really bad and crying. And then he just like told me to like Google the place. And I knew that this place sold guns and like, he won't ever let me have the gun like in my possession. So like he carried the gun in here and put it down on the counter and then he walked out because he's a felon, so he knows he's not supposed to like buy or sell guns. I think he killed someone before, but I don't know. It doesn't say on his record. It just says felonial assaults and stuff before I met him. And then we just came here. And then the guy put me in the back room and I called you guys, or he called you, then I talked to the lady.
Okay. I'm going to take some pictures of you. He's going to go to jail today. And we're going to make sure that PPO gets fully served. And so there's a record of it being served. And so that just look forward for me. Look forward. I'm going to get a close up of your cheek, okay?
he doesn't listen to it.
You can call us. If he violates the PPO, call us immediately, okay? And we will come arrest him. Can you pull up those videos and photos again?
Yes. I was gonna try to find the video. I have to find the video where he said why he choked me.
Can you just pull up the photos?
Just the one from. Okay.
Just the video of him with the firearm in his hand may be enough to get him charges.
Myself so I can add attention to the report, okay?
As a felon.
Do you want to do the videos too, so they know he had the gun?
Yep, I will get everything that is going to be necessary for the case.
It only was on Monday that I took those, though. I had the other ones. I sent to my email because he always gets my phone, so I always have to delete everything.
Okay. Do you mind if I email him?
No, go ahead. He's probably just gonna deny everything. He always does. Go up.
And this is from Monday.
Yeah. Probably screenshot it or. I wonder if he took my driver's license. I feel like such a weak person. Do I have to go there to the court and around him? When he gets arraigned, do I have to be there?
Not when he gets arraigned, but when it goes to trial, you'll have to be there.
Did he try to run in the car when he came?
No.
Was he in the passenger or the driver passenger?
Passenger.
So he has my keys.
Is the car registered to you?
Yeah, it's my car.
Okay, we'll get the keys back from you. Said anything to those other units. If he has keys to the car, you can get things for my RP. Oh.
Wow, look at that.
Disregard. They appeared.
They appeared.
Thank you. Do you want to text me what your charges?
I'll call in jail. And then it's going to be felonious domestic.
So they went to the police station together. He brought the gun and put it down.
They're not coming through. Can you pull up your email to see if they sent?
It's probably better if I do it like one at a time. Which one do you want the videos, right?
Yeah, all the pictures and videos of
Okay,
him
with
on
the
Monday.
Okay.
And then obviously the ones from today.
Sorry, Ramil, you made me do this. I just updated my iPhone.
You can't talk over the video.
You're going, you did it?
Yeah.
Ma'am.
Her crying is in court. That's live. She's on the witness stand right now. We're watching the video because she said she doesn't remember any of this.
You have to it only keeps videos for 30 days on iCloud. So when you get it, you're gonna have to I don't know, record it a different way. Which one did you put, large?
Just the actual.
Oh, okay. Usually I do medium. If it doesn't do it, then I'll have to use mail drop. If you don't get it this time.
She gets all the tech. That's true. That's how it works. Maybe give her the Wi-Fi password. That'd be a little faster.
Okay.
Did it work?
3 out of 10 to 3 out of 17.
70.
You guys can become this blue cell phone in the passenger seat belongs to him.
Is the blue cell phone his or yours?
I'm sorry.
There's a blue cell phone in the car. Is that his?
It must be because I have mine.
Okay. 17. She's saying it's not hers.
Did you get it?
I got something. Let me check. So I got the pictures.
We're court hopping right now. This is just something happening live right now up in Judge Kirsten D. Simmons.
So this should be coming through just slowly.
I'll do mail drop in case too if you want to do it if you don't get it because you have to use mail drop. Just let me push the send part.
I just want to push the send part.
What should I put subject?
It doesn't matter. You don't even.
So the prosecutor's using her to prosecute her ex on the original allegations she made at the police station, which she has since recanted and then forgotten.
Mail drop usually is the only way you're gonna get it.
Well, if there's an issue with the videos, I'll contact you to send it a different way. But let me go get the gun, and then
Will I get it back?
once the case is done, I'll be taking it for evidence.
How am I gonna push it? Well, it's jammed anyway, so I can't.
Something. Yep, you'll get it back again once the case is concluded. But hang out for a second, and I'll get you a case number, okay? Yep.
And stopping at 27 minutes and 22 seconds.
Thank you.
Crawford, is it still your testimony that Adrien Johnson did not do those things to you?
Some things he did, some things he did.
What were some
Now
of the
I
things that he
remember
did?
why my doctor said I just associate.
Ma'am, what were some of the things that he did to you on December 20th, 2025?
On December, no, I said the stuff that I said in here that he did wasn't on December 20th.
So you're saying the things he told the officer that he'd done to you before then was true.
In Myrtle Beach, he just showed me.
But your testimony is still that he did not put the gun into your face and pull the trigger that day.
Yes, my testimony showed that. When you asked me the question about did I tell the police that I wanted to save him or something like that? Did I tell the police that day too? You said I told the police that I wanted Adrien to be safe in jail or something like that. You asked me something like that.
Ma'am, I can't answer your questions here.
Okay, can you repeat the question that you said earlier?
What I asked was, at some point, did you say that you had made up these charges to keep him safe in jail? That was the question I asked before. You said you didn't remember doing it. Now,
I just know that I was disassociating, but.
Ma'am, you have to answer the questions I ask and only when I ask them. Now, Since that day, he has called you from jail, correct?
Not recently that I remember.
Since that day, he has called you from jail, correct?
He did call me from Lansing jail that I remember and asked me why would I accuse him of something he didn't do.
Did that have any impact on your testimony here today?
No.
Yeah, I have no further questions for this witness.
Here comes defense.
Cross-examination.
Thank you, Your Honor. No cross-examination. Thank you.
I have a question. Ma'am, you said he didn't call you from the Ingham County Jail?
That I remember. I thought it was the city jail.
Did you have any video calls with him?
My son did.
If we showed you People's Exhibit 8 with a picture of you talking to him on video, would that refresh you?
I guess. It was my son's visit, though. I think. Yeah, that was my son's visit.
But is that your picture? Is that you there?
That's
not your son in that picture, correct?
That's his name right there.
I didn't ask about the name. That's not your son's face, though, correct?
No, that's me. I told him I was sorry. Yeah.
Okay, so you did have a video call.
That's a video call. Yeah, not a phone call.
Any redirect?
Actually, very briefly, didn't you email myself and the defense attorney at the February 9th saying he's threatened you?
Your Honor, I'm going to object to this because now Mr. Pfeiffer is potentially turning himself into a witness as it relates to the contents of that communication.
It's impeachment.
That's for the purposes of impeachment, so the objections are ruled.
I'm sorry, repeat the question.
Sure. Didn't you message myself, Mr. Sarks, Michael Taylor, Stephen Cornish, and Detective Kennedy saying that Adrien threatened you? February 9th.
Can I see the email? Because I don't recall seeing threatened.
So you don't recall?
I don't recall seeing threatened, no.
Ramil
threatened me.
sorry?
Ramil made me put the PPO on Adrien.
said
Ramil
what?
asked me to do all these things because
What was
I'm
this?
testifying.
You
This
said?
is my ex-husband. He had me serve the PPO against Adrien in the Berrien County Jail.
Okay.
And he's the one he's got witness intimidation charges for me right now because of all of this.
I'm not going to argue about semantics here.
I no one's asked me anything about Ramil. And this whole case
Because
is
he's
related.
not relevant to this case.
But he's the one that told me to do all this stuff. He's the one that's threatening to kill my child. He's the one threatening to kill me and Adrien. Like, that doesn't count for anything.
Ms. Crawford.
He's the one that my brain is messed up. He's the one that had the guns, not Adrien.
So
That's why I disassociate, because I was getting them confused in therapy. That's why they stopped my EDMR treatment, because I was getting Ramil and Adrien confused because Ramil did so many horrible things to me. That's why he's been in jail for almost 2 years.
So
and I worked with the police to record him talking about another murder. I worked with the police, and that's why his friends are threatening me. His trial is supposed to be January 6, 2026. And that's why I was getting the calls on that day. That's why I thought killing myself would be better, because then I wouldn't have to testify and my family would be safe. That's what matters to me, is my family being safe. Yes, Adrien choked me. Yes, he's abused me, but he didn't try to kill me that day. I tried to kill myself, and I will not retract from that. I said that when I emailed you, I remember emailing you saying that I should keep the distance, because when I talked to Judge McCormick, she said that we need space when we had the PPO violation that she didn't give him. And she also said, and I told her about Ramil, like, forcing me to put all these things in this PPO to try to make it seem like Adrien set him up so he wouldn't go to prison, because he's facing life from all his other crimes. And Judge McCormick said, just give it space and everything, and I just don't feel like I feel like I can't protect Adrien from myself, from my own brain. Like, look what I did to him just because of my fear of Ramil. And it's just, I don't know what to do. I don't know what to do. I don't know how to protect my family. I don't know how to save myself from all these guys. I don't know what to do. I'm just doing what they're telling me to do. Like, I don't know what to do because I don't want anybody to die. I don't want upset. They know where I live. They know what car I drive, and I don't even know who these guys are. That's why I filed the Clancy police report. That's why I showed the Lansing officer all the blood calls of these guys calling me. Like, he knows that. That's why he said that he would protect me with this gun. That's why he did that. Adrien's not innocent. He has abused me, but he didn't try to kill me that day. He's never used a gun on me. Vermeil is the one that used the guns on me. Vermeil is the one that carries the gun. It's not him. It's not him.
But we've got video of Adrien.
I'm sorry if I lied. I'm sorry. If you think I lied, it was just because I was so much trauma happened to me that day. I got the calls from the guys again, and then his trial was coming up, and I already have the preliminary trial, and for him, and he just kept, even when I had a video call with Vermeil, he said, why isn't he in jail? Why isn't he in jail? Why am I in jail? Why isn't he in jail? Like, that's all. He wouldn't get these guys to stop calling. I even tried to put money on his books and everything and tried to get him to stop, and he wouldn't stop. And he knows it. And Adrien knows that they was doing this stuff to me. He knows it. But now when you threaten my son, it's different. When you threaten my child, it's different. It's different. You don't know what I've been through with Vermeil. You don't know what I've been through. You don't know. Adrien didn't try to make me divorce him, Vermeil. Vermeil was gonna kill me if I did all this stuff. I ran away to Myrtle Beach to get away from Vermeil. I didn't want to leave my son. I've never left my only child. Adrien went with me willingly. But Vermeil made me say all this in the PPO so that he made me deliver to the jail so that he knew that I did that. So that I blamed Adrien so that it looked like it was set up, but I told him it's not gonna work because I already told Detective McAfee that I already asked him if he wanted me to record Vermeil admitting to the murder, and he said yes. So I worked with the police to help him give Vermeil away because he was killing so many people and they never caught him, so I was trying to help so he wouldn't kill anybody else. But his friends are killers too. They just feel like it's just different in Benton Harbor how they are. I don't know how to describe it. It's just, they just don't care. And I know they've been hearing gunshots outside my apartment. I never heard those before. Anytime I've lived there. I know that they're wrong. The Lansing police said the only thing they can do is just go around my apartment. I'm sorry.
On February 9th, 2026, isn't it true you said, and I quote, in that email, I don't want to bother you guys again. I just really need protection. My doctors ask me every session, do I want to kill myself? And I always say no. They know Adrien was abusing me and trying to kill me. Adrien was upset. I moved on after I got the courage to divorce him in 2023. He went crazy. He showed up at my husband's house to kill him too. He has a nice side, but when it comes to me, he has control issues. I never wanted to take him from the kids. I just know that when he went in that gun show, if they fixed the gun, it most likely wouldn't malfunction again. My doctor says the trauma lives in my body. My brain gets confused during the trauma, but I handle my life well. I'm a good person. I follow the law. I wanted to call the police so many times to help me, but whenever I didn't tell Mizzou, I would get choked worse when he would get out of jail the next day. I couldn't even bring myself to serve him the PPO. When you are yelled at and choked all the time, it takes away your strength. Fear overcomes you. I think it's a good idea to keep the no contact order to other people. He's an ex-gang member and has people that will hurt me. He even had guys calling me, telling me not to testify on a case to change the narrative. It was Adrien all along. I recognized his friend's voice. If he bonds out, I am cooked. I know the judge could tell I was being threatened. That is why she didn't want to accept that affidavit. I just don't know how to not be scared of him. I've had so many emergency room panic attacks with blood pressure in the 200s. I just do whatever he says. I am very blessed that God saved me. I want to apologize for being scared. Thank you all for your time and effort. I know you all are very busy upholding justice. I respect you all very much. Law and justice is something I fight for as well. Isn't that what you sent to all those parties I listed before on February 9th, 2026?
Yes, but I also talked to Pernille that day in jail.
Your Honor, I have no further questions.
I do have a follow-up question, ma'am. What are you right-handed or left-handed?
Right-handed.
Okay. Can you demonstrate to me how you put this mark on your face? And so you took the muzzle of the gun and you
went like this.
and rubbed it into your cheek?
Yes.
Okay. And where was the defendant when you did this?
Outside.
Okay, and then when he comes back, or did he come back inside after that?
Mm-hmm.
Is that a yes?
Yes.
Okay, and then how did you go from this point where you're intentionally putting a gun mark on your face to you both going to Dicker and Dale?
Because I asked him, because the gun jammed when I did it, I didn't want to carry it. I was afraid it would go off, because once after I did it, I was like, I can't believe I would do this to myself. I can't believe I would take myself from my son like this.
Okay, so what you're saying is that you put that to your face, you were intending to kill yourself?
Yes, because then I wouldn't have to testify against Ramil. I only had 2 weeks left to testify against him. Now it's postponed again. It's been postponed for a whole entire year. I just didn't want to save them. Those guys kept calling and calling, and they keep calling. And they're telling me if I testify against Rome, they're going to kill everyone. Like, what am I supposed to do?
No questions, Your Honor.
No follow-up, Your Honor.
You may be excused, ma'am.
Thank you.
You can call your next witness.
Thank you. Let me check who's here. I know Officer Larson will have reached out to. I'll have an answer for the next.
Wow. I'm not sure what the court can do with that testimony. The way she demonstrated the use of the pew-pew was an improper method of handling if the intended goal was to discharge a shot. She instead demonstrated that she was trying to mark her face with the end of the pew-pew. But then she said it jammed, but she wasn't holding it in a way that it would even be fired. It's really confusing to try to sort out what is true and what is not true. I can tell you one thing. She needs help. It sounds like she has professional help ongoing, and I think that needs to continue. I'm worried for her and for her family, specifically any children she has. It sounds like she doesn't have the best choice in men, which obviously is not going to contribute much positively to the situation she's in. But, wow. I've never seen a witness quite go off quite like that in court. Sloth Life just gifted 5 memberships. Sloth Life, thank you very much. I'm not sure what's going to happen with Adrien here. Or what's his name, Roma or whatever, the other guy. Apparently both of them are in jail. Both of her exes. Married to Adrien first, then divorces him.
Swear or affirm the testimony you're going to give is the truth and the whole truth under
Marries
penalty of
Roma,
perjury.
gets divorced at gunpoint, is now back with
State your
Adrien.
first and last name and then spell both.
My name is Ayden Havard, Hayden, Havard.
Thank you, Your Honor.
I think this is the
Keep this
detective.
exceptionally brief. Where are you currently employed?
I'm employed with the Lansing Police Department.
And what is your role there?
My role is a law enforcement officer.
Were you working that capacity on December 20th, 2025?
I was.
On that day, did you end up going out to the Dicker and Deal pawn shop in Lansing?
Yes.
Did you end up making contact with Brandy Crawford?
Yes.
Did you end up recovering a gun?
Yes.
If I could retrieve, I think it's People's 3.
So the Dicker and Deal pawn shop,
People's
that was
4,
the
my
break
mistake.
room So this they were in. That was the pawn shop break room.
Showing you what's marked and admitted as People's 4. Is that the gun that you retrieved? Yes. And then I'd like to approach what's been marked People's 5 and 6. Do you recognize what's in People's proposed 5 and 6?
I do.
How do you recognize them?
That is the firearm and ammunition that I seized on the stage.
Does that appear to accurately reflect what you received?
Yes.
At this time, people would like to submit People's proposed exhibits 5 and 6 into evidence.
Mr. Sarks,
Thank you, Your Honor. Objection by foundation.
objections on rule 5 and 6 are admitted.
Was there anything notable about this firearm when you examined it?
The gun was jammed when I took it into possession.
And the hammer there in People's 4, is that cocked back there?
It is.
Is that the firing position for that revolver?
Yes.
And those bullets, were those in the gun?
Yes.
Thank you. Your Honor, this time people have no further questions to this witness.
Cross-examination.
No questions, Your Honor. Thank you.
You may be excused. Thank you.
Apologize for what this. No. Your Honor, just as a point of order for officers for future cases, if their wife is actively having a baby, they're allowed to not come to this exam, right? And get a different date?
Right.
What? Congratulations, it's a boy.
Congratulations.
Seriously, congratulations. Go, let's run.
Appreciate it, guys.
He's in labor. What?
Thank you. If I could publish 5 and 6 to the board.
Take the warrant. Take the bench warrant. Oh my goodness. Call him first.
People call Officer Isabella Dominguez.
Congratulations on the birth of your child. Our condolences on the divorce announcement that's going to be served to you by missing the birth of your first child to be in court. Oh my goodness. This prank caller will not stop calling. Hang on. Hello?
Hello. Hello.
You sound like a robot. It is a robot. Man, this court, just in the few minutes we've been here, has had a little bit of everything. Your Honor, for the record, let me verbosely say that the officer who I'm sort of detaining, standing here next to me by my side, who's just testified for this court in the case in the matter at hand, is currently missing the delivery of his child. His wife's in labor. In the future, run! Shut up! Shut up and run!
Testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, I can have a seat.
State your first and last name and spell both.
Isabella Dominguez, ISABELLA DOMINGUEZ.
Thank you. Good morning, Ms. Dominguez. Where are you currently employed?
City of Lansing Police Department.
And what is your role there?
I am a police officer.
How long have you been a police officer at the LPD?
A little over 1 year.
Now, were you working in that capacity on December 20th, 2025?
I was.
On that day, did you end up responding out to the Dickering deal in Lansing on Cedar Street?
Yes.
Did you end up making contact with Adrien Johnson?
Yes.
Do you see that man here today?
Yes.
Could you please point out where he's sitting? Maybe something that he's wearing that the people around him aren't.
He's sitting right there.
The record could reflect she's identified the defendant.
Any objections to identification?
Yes, Your Honor, like a foundation. Thank you.
Noted.
Thank you. Did you speak with him?
Yes.
And without getting too into the weeds, did you talk with him about a firearm?
I did.
And what did he say about that gun?
He said that it did not belong to him. It belonged to Joanne Crawford. He stated he knew where the gun is located within the house, kept under the bed. He stated he has touched it in the past, but he's never used it.
Now, were you one of the officers who took Mr. Johnson into custody? Did you end up running him through the official government systems?
Yes.
And did you end up looking at his criminal history?
Yes.
And did you see that on March 4th, 2019, he was convicted of possession of controlled substance less than 25 grams out of Kalamazoo County?
Yes.
Thank you. Your Honor, at this time, I have no further questions for this witness.
Cross-examination.
Thank you, Your Honor. Just briefly, was Mr. Johnson in custody when you were asking him questions?
At that time, he was detained.
Okay. And was he advised of his Miranda rights?
Yes.
Okay. And did he consent was he advised of his rights to counsel?
Yes.
And did he waive those rights?
No. I'm sorry. Yes, he did.
No, I mean yes.
And he was not free to leave at that point that you were questioning, correct?
Correct.
Okay. Thank you, Your Honor. Nothing further.
No further questions.
Thank you. You may be excused. Thank you. You can call your next witness.
I have no further witnesses, Your Honor. People would rest.
Is the defense calling witnesses today?
No, Your Honor. Thank you.
Give me 5 minutes.
Judge has 5 minutes. She's going to go in the back room, scream into her pillow, punch the punching bag for a little while, and then come out and make a ruling. We'll sit tight and see what the outcome is. This looks like a preliminary hearing as we're leading up to a potential trial in this case. And it can be interesting to see if this goes forward with what the judge has to deal with. We do have, if one of the charges involves a felon in possession of a firearm, there seems to be plenty of evidence, both video and testimonial, to give credence to that charge and let it proceed. As far as the domestic ones, sadly, I don't know how you could rule on that. It's a whole mess. It's a whole mess. The officer was on the stand. His wife was in labor. And the prosecutor waited until after asking him all the questions to announce to the court that his wife's in labor. They would have, yeah. He has a lot of charges in this case. It sounds like some of them might go forward. Could be facing life in prison if he gets hit with everything, with all the, if they're consecutive and all. We are waiting to jump down to San Antonio, Texas. Right after lunch, we expect to go down there and pick up the case with Judge Boyd, which we started yesterday. That was a murder trial with a huge time span between the killing and the trial. 24 years to be exact. 22 of them, the defendant was in Mexico on the run. Has been extradited, now returned here. So the witnesses are testifying pre-Celebrite, pre-cell phone tower pings. It's really like taking a step back in time in prosecution, as the evidence is basically based on their own recollection, which has faded over time and is dependent heavily on handwritten reports the police took. So, good stuff. We'll give the judge just a couple minutes to decide what to do here. Okay. Trial with jury would be interesting. That's the one down in Texas. That's a jury trial. Also, Monday, don't miss it. Corey Richens' trial begins. I'm in the media pool for this one. We'll be having every minute of court brought to you straight from Summit County, Utah, where Judge Krasnick is absolutely incredible. And you guys are going to love his voice. Not necessarily all his rulings, but love his voice. It is like butter. It is so smooth. I like to just hear him rule, read and rule on things. It's a lot of fun. We might also have court watchers in the courtroom, which is awesome. A couple of you reached out saying that's going to be the case. Just be mindful. The Utah docket should have, or the court website should have the decorum order. It's 8 pages long. The judge has a bunch of rules for media members, which won't apply to you guys, obviously, but for media members, there are strict rules, even so much as to how high you can lift the device off your lap. You have to follow the rules or you get kicked out. You don't want to get kicked out. This judge is very serious about things like that. So Follow the rules. No logos, no signs, no stickers, no outbursts, no interruptions, no getting up and getting a drink and coming back in. It's a tightly run court, which will make it good for us audio wise. If you haven't noticed, also I'm sucking down not my progressive soup drops, which we might be trying tonight on the podcast if Thomas got his, but this is green. You can't see it because it's green. Hall's Defense and cough and throat relief, like their candy. This is how I'm getting through the day, so try to keep the mouth noises to a minimum. But tonight, possibly, I'll have to check with Thomas. We might have some different drops to try, and that's specifically these ones right here from Progresso. Soup you can suck on. Yes, they are candy. They look a lot like a cough drop, but taste a lot like soup, supposedly. We've purchased this to try them, so you won't have to. So be here for the podcast. That might happen tonight if he got his. Do those have cellophane wrappers? Paper wrappers. That's what they are. Cherry Ludens. I'm not a big fan of cherry. I bought cherry as well. Halls. I'm a big fan of Halls. And man, if you can get the ones that have like the liquid center, that's heaven. It's like, that's the way it should be. All right, the face I just made. Wait till you suck on a nice cough drop that tastes like chicken broth. Oh man, that's pretty good. Or tomato basil, little tomato soup, beef stew in candy form. Good stuff. That's why I made the face. I like the vitamin C drops. Is it possible to get? Is it possible to get these green ones? Sorry, you can't see them because they're green, obviously. Is it possible to get these in a like the sugared version? Or are they all sugar-free? I can only find sugar-free now. Oh, I just got an email. Hang on one second. I need to... This violates everything security-wise. Ever. Okay. Verify your recovery email. I just texted the code to somebody. Hey, Little Miss, how you doing? Speaking of Little Miss, my daughter has rediscovered with the occurrence of spring the joys of metal detecting. So she went in and found our metal detectors and said, oh, man, sorry. She's like, can I borrow one of your metal detectors? And she's been out recovering artifacts from the ground and loving it, and now wants to head down to the park. So possibly this weekend we'll get to some metal detecting in, which is a lot of fun. Hold, please, while I navigate a YouTube content claim that just hit us. Holy smokes. Remember the Carly Gregg trial? The child murderer, Carly Gregg, just got hit with a content claim for about, 18 seconds of something that was used in the episode of somebody else's podcast, and they just tried to strike everyone who used it. Oh man, that was way back in the day. It's can't even see who the claimant is. Just gives an acronym, which I'm not going to share. Holy cow, dude. 1 second there, 4 seconds here, 2 seconds there. Done. Dealt with it. It was not music. It was not music. It was, I think, a subpoena live chat in the Discovery. No, it was just trial audio that somebody used little clips of trial in their podcast. And then they go and they say, this podcast is my content. So it's copyright to me. And YouTube finds anyone who has any matches to any of this and hit them with a copyright claim, so I get any money from their videos that they've made with my content. Ever get an AP strike? Not a strike, no, but AP I've had to work with a couple times. We fully expect Corey Richens to do the same thing. A couple of the stations that will be also in the media pool are aggressive, super aggressive about protecting their intellectual property, which they include as everyone else's intellectual property as well. So we fought it before. I sent a nice demand letter. They fixed it within about a day. Where can I mail you some regular Citrus Halls defense? Oh, give me the P.O. box, please. To the grand jury. We went all over through Walmart. Couldn't find the regular sugar ones. They taste so much better. Waiting for court here, waiting for the judge to step back in and make her ruling on this. I think it's going forward. There it is. Can I thank you in advance? Data grand jury. Thank you very much. There's the P.O. box. Copyright isn't fit for the YouTube. Oh my goodness. Acne Goose. I deal with this every time I work with my YouTube partner, which I need to make some more member videos. They're bugging me about it. The copyright system is designed to protect the copyright holder, and it can be abused very easily. Now, I will give them this. YouTube is very good about, once they investigate and discover that the copyright claimant, the person who filed the claim, is doing so maliciously or disingenuously, then they strike back, and they strike back hard, like ban from YouTube type. They fix it. But the problem is a lot of these are, oops, I didn't realize it struck everybody that had ever used the same clip. Well, that's what it does. So if YouTube even has a person to look at it, that's the biggest problem. It's actually getting the person. That's why I'm doing, in part, that's why I'm doing this program with my content, my brand, not my brand manager, but my account manager, so that I can get better access for issues like that. Judge is back. Let's hear what she has to say.
Thank you, Your Honor. People are going to be seeking bind over the original 5 counts as well as 2 added counts relating to what's shown on the video from December 15th, 2025. That being added count 6 of firearm possession by a prohibited person and added count 7 felony firearm, because it's literally on camera on that day holding a gun. It was not supposed to be. But to the incident on December 20th, Brittany Crawford told the officers, "This man put a gun into my cheek and pulled the trigger, and it jammed." He then made her go to Dicker and Deal to get a working gun. She took a photograph of the of the indent left in her cheek shortly after it happened when he had went outside. She was able to. And then once at Dicker and Deal, she had them call the police for her. The officer recovered the firearm and found it not only loaded, but jammed in the firing position. I said this before, it is a miracle that she is still alive. She should have died when that man pulled the trigger. We're lucky that she didn't. But that is assault with intent to murder. He tried to kill her, and he just failed. And it's, again, by an act of God that he failed, that a revolver of all things jammed. And then, possession by a prohibited person, by someone with a felony conviction, as testified to by the officer. He's not allowed to have it. Not supposed to have it. He had a gun. Which is why we have with intent to murder for count 1, firearm possession by a prohibited person for count 2, and then accompanying felony firearms for each. Now, I could not possibly address bind over without addressing Ms. Crawford's testimony here today. We have two stories. We have the story that was told to the officers that day, supported by the physical evidence that they recovered. And then we have the statements here from Ms. Crawford, which varied, which frankly, the people do not believe, especially given that it kept changing. Because it was, no, he didn't do what I did to kill myself, but then it was, no, 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 I made this all up because my ex-husband, Rome, is threatening me and making me do this. Those two things don't mesh. Those two statements don't work together. What is significantly more plausible is that this is a woman who's been abused by multiple men, including Mr. Johnson, who has assaulted her, choked her, threatened, who, as she told the officer that day, threatened to kill her if she went to the police, who, when she had gone to the police in the past in Kalamazoo, he'd just get right out and then he would choke her even worse. And that the reason that she finally came forward was because, well, he said that he would kill me if I went to the police, but today he tried to kill me and I didn't go to the police. So at this point, I'm going to the police. And then we have the fact that he has been contacting her from jail, that he's been having other people contact her on his behalf. She did not want to talk about those contacts, which is why she kept saying, no, no, I didn't actually talk to him from the jail, even when confronted with the written records showing that he had called her and talked to her for lengthy periods of time. And while she said, no, the fact that he has been talking to her, the fact that other people have been talking to her has not affected her testimony today. The fact that that happened in between what we saw when she's talking with the officers at Dicker and Deal and today, she wants to say that didn't affect her testimony. That didn't affect her changing statements. The people do not believe that that is true. The people believe that that absolutely affected her, that that is the reason why we're dealing with a recant, as we do in many domestic violence cases, because we have a man violating court orders to continue to exert his power and control over her that he had built up over years of a relationship before he got to this point. I would ask this court to not reward him for being such a successful abuser. That is why the 27C hearsay exception exists. Literally, when the legislature wrote it, they noted how there are recantations so frequently in these cases that it would be a disservice to justice to not allow the statements of police officers in as substantive evidence. So I would ask that you bind over on the requested 5 counts and then an added count 6, firearm possession by a prohibited person, and added count 7, accompanying felony firearm, both with a date, December 15th, 2025. Thank you.
Mr. Service.
Thank you, Your Honor. The defense would object and request respectfully that Your Honor dismiss all of these counts. Respectfully, the people have not met their burden of proof. I will just start briefly with the requested added counts of possession by a prohibited person and referring to count 2. The extent of any testimony regarding any alleged previous conviction came in through an officer, Dominguez, and it was only to the effect that the officer had reviewed a lien entry or something along those lines. Forgive me, I don't remember what her exact statements were, but Your Honor, respectfully, that should be insufficient for the purposes of establishing the important elements as relates to that particular charge, because in contrast to other scenarios, we don't have a certified record of conviction. We don't have any more affirmative or dispositive evidence that there actually was a conviction in place. Respectfully, this officer's testimony about something that she might have seen in a criminal history is insufficient for the purposes of establishing that element. Obviously, Your Honor, the testimony was what it was about allegedly Mr. Johnson being in possession of the item. There's a lot of very clear testimony that it was Ms. Crawford's gun, and in terms of the time, dates, and stamps, respectfully, perhaps there was a mistake there. I don't know. We're talking about cell phone video and of course, Ms. Crawford's testimony. as it relates to the alleged incident on December 15th. And since we're discussing Ms. Crawford's testimony, I will then transition into respectfully why counts 1 and counts 3 should be dismissed at this time. And respectfully, we do have competing versions of alleged events here. Because the statements are so inherently contradictory, and because Ms. Crawford did raise serious questions about her previous statements to the police, respectfully have not met their burden. And while credibility is a very low bar for the purposes of a preliminary examination, still based on Ms. Crawford's statements, based on the totality of her presentation of her statements, based on the numerous contradictions across all her statements, respectfully, the people have not met their burden, and she did, testify to a narrative which would negate count 1 directly, albeit certainly the prosecutor has attempted to impeach her based on that statement. And with that, Your Honor, that would also apply to that count 3, which is felony firearm, which attaches to count 1. So in totality, Your Honor, based on all the testimony here, the defense respectfully requests that all these counts be dismissed. Thank you.
He shot for the moon. He's not going to get it. But...
Very briefly, Your Honor. People's Exhibit 9 that had her statements to the police in it, that is not impeachment. That is substantive evidence admitted as such. Secondly, the officer's statements about his criminal history is sufficient for a probable cause standard for those elements for possession by a prohibited person. That's what we're here for, probable cause.
Thank you. Okay, Mr. Johnson, today was the date scheduled to proceed with your preliminary examination, which we did have other dates where issues were addressed relative to how we could proceed with this preliminary examination. But today was the only day we took testimony as it relates to probable cause. So the burden is on the prosecutor. They have to establish that they have sufficient probable cause that a felony or the felonies you were charged with were committed, and sufficient probable cause to charge you as the individual who has committed these alleged acts. So this is not trial. They don't have to prove each other beyond a reasonable doubt. They only have to establish more than mere suspicion that these actions took place. The court will be the sole and only, determiner of any credibility issues at this juncture. And then we also can weigh the people's likelihood of success at trial. I'm also going to measure whether or not the evidence raises reasonable doubt about your guilt in an effort for it to proceed to a trial. We have here first testimony from, we had testimony from Detective Stephanie Kennedy. She was able to identify you as the person in the court as Mr. Adrien Johnson. Then the testimony was elicited from Brandy Crawford, who is the alleged victim in this matter. She testified that on or about the date of December 20th, 2025, that she and the defendant were present at the address of 1030 South Holmes in Lansing, Michigan, which makes venue in this court appropriate. And she identifies that address to be her home. When questioned, she did testify that during that date, she and the defendant left her home and went to Dickering-Dale. When questioned about why she went to Dickering-Dale or why she was speaking with the police, she had a lapse of memory, at least that's what she testified to. She admitted to owning a .22 revolver. She stated on her direct examination that she, on the date in question, pressed this .22 revolver up against her cheek and it left a mark. Again, there was some back and forth about whether or not she had any recollection of the incident from that date. It was unclear at first if she recalled all of the incident, and later she said it was portions of the incident that she recalled, other portions she did not. The prosecution was able to play a video at some point to help refresh the witness's recollection of what she shared with the police on the date and time in question. The prosecution also admitted some exhibits. One of those exhibits being People's Exhibit 3, which was taken on or about December 20th at 12:05 p.m. And it's a picture of the alleged victim with a circular marking on her cheek, which appears to be consistent with that would have been created by placing the firearm up to her cheek. There was also People's Exhibits 4 and 5 and 6 that were admitted that shows the firearm in question that the witness testified was in fact her firearm. This case has got to be one of the most disturbing situations I've dealt with since my time on the bench. And the reason why is because we have one of two things happening here. Either way, it's a grave danger before us. Either the danger is that Mr. Johnson is extremely violent and volatile and attempted to kill Ms. Crawford on or about December 12th. Or the danger is that Ms. Crawford is extremely manipulative, conniving, and lying. And because of whatever's going on, not just in her psychosis, but whatever's going on between her and this supposed other person, I don't know if his name is Romeo or Romeo, that Mr. Johnson has now been accused of a crime that's punishable. He's facing up to life, I believe, and then has been sitting in the custody of the jail since December 21st. And if, in fact, Ms. Crawford would be lying, she made this all up, and he's wrongfully sitting into the jail. Again, the court has to assess credibility. And I think it is undoubtedly, without question, that we have some credibility issues here in this court. Ms. Crawford has been a very difficult and hostile witness from the beginning. I think even before we ever took any testimony, there was information or documents sent to the court that were purported to be an affidavit, I believe, from Ms. Crawford that she had notarized. And in that statement, she recants absolutely everything that she would have told the police. At the time, the court's not clear what it was that she told the police, other than what was in the affidavit of probable cause that led to these charges being issued. Again, one being assault with intent to murder. During that same time frame, the first court date, the court is also made aware of allegations that the defendant has violated the bond conditions by having contact or communication with the protected party, and that an investigator would be assigned. The court did arraign Mr. Johnson on those violations. We've since had a hearing today to which the court sustained the violations. However, although the court sustained the violations, I will say this: I found it to be interesting that neither of the parties, although this has been investigated, there's been reports, you even have exactly what was said on these calls. Neither the prosecutor or even the defense attorney bothered to question the witness about the nature of these conversations during these protected calls, because they're important. There was no testimony here or no evidence brought out that would support that, although the conversation may have included some information about this case, that it was the defendant attempting to put pressure or to intimidate this witness. That was not brought forth. I think it was very interesting that no questions or statements were brought into the record although the court obviously got a police report with the statements and everything that was stated in there in order to move forward with the PA 53, the court already has judicial notice as to the nature of these conversations. The nature of the conversations, although still a violation of Mr. Johnson's bond, was very consistent with the affidavit, and we watched a witness go on for minutes, hysterical, stating again things that are consistent with the conversations that were had either directly or through third party on these conversations that were not supposed to be happening with her through, I believe, her son or his son while he was in the custody of the jail. Multiple times, even in other appearances before we could even be officially on the record, has Ms. Crawford tried to blurt out something about a case in another county involving someone named Rome or Romeo or Ramil, who was the cause of whatever prompted her to say what she said that landed this defendant in court. Ms. Crawford was counseled and advised multiple times that she should get an attorney because what she was doing would constitute perjury and is and should be charged and actionable under the law. She was counseled multiple times. It will also be stated on this record that she made the court aware on the previous record that she did not care, that she felt she still needed to say what she needed to say, although the court would not allow her to do that without advising her to try to get an attorney. She returned to the court, I believe it was January 9th, without an attorney. During that time frame, or in between that time frame, she had filed more things and had made multiple communications with the court demanding ADA accommodations and other requests for advocates and such, to which the court addressed on the record during the January 9th court date. After that January 9th court date, even though the court went through what was requested by the victim, the alleged victim, verbatim on the record, line by line, the court later received communication by way of Ms. Crawford that she was, I think she called the court and said that she was going to commit suicide, to which the court staff sent law enforcement to do a welfare check. My understanding is that she was taken to the hospital and hospitalized as a result of the same psychosis that I believe brought us here today. The court also later received complaints that had been filed, I think, through the state court administrative office and some requests through legislation indicating that Ms. Crawford disputed some of her requests, although the court made them clear on the record what she requested and how it would be addressed. She also stated that her rights had been denied by the court, which was untrue. Since then, since I haven't addressed that request, we received numerous other communications from Ms. Crawford, even this week or the last week and this week in preparation for today's court date. I have no reason but to find everything out of her mouth to lack credibility. I believe that she's lying, or that she lied to the police, I should say, on the date and time in question, and that's because it's corroborated by the communications they had on these phone calls. There wasn't communications about you need to remove this or you need to take care of this. Their communications was her repeatedly apologizing, saying the same thing she said now, which is, I did this because I thought it was going to be to protect you and it was only for a short time. And what I hear or see from the defendant is somebody who is crazy in love. And although someone would lie and put you at risk, put your life at risk, and lie and say you tried to kill him, he's like, I understand, and you know, whatever, I'm just happy I heard from you, whatever the case may be. There's nothing there that shows me that Mr. Johnson was trying to intimidate her or to control the narrative, but that she was making it clear why she lied in the first place. And even her son appearing to, or whoever the third party was having the communication, appearing to support that this statement or these statements made to the police were lies. I watched the video that was played in People's Exhibit 9, and I can guarantee you it read to me nothing more than a performance. I believe that the witness is conniving. I believe she is a master manipulator. I believe that there was enough evidence there for the prosecution to pick that out and to know that this is not a case that should move forward, but maybe because of the way the scenario rolled out, where we have someone who's trying to perjure themselves, we have to go through these steps so that we can move forward. But I believe and I hope that the prosecution intends to charge her for perjury. We have a man that's been sitting in jail on a $400,000 cash surety bond since December 21st because someone lied. And they got before this court and lied again. And if the prosecution for the Ingham County does not issue charges against her, it's very telling.
Wow.
There was also evidence or enough evidence there based off her statements, the phone calls, and her attempt to recant that maybe the prosecution can have the investigators look into what she's saying as to why she lied. Maybe that could corroborate the fact that she's saying that I lied because this person has been threatening me. Did anybody even bother to look into that? Whether they did or not really doesn't matter. The case is dismissed for lack of probable cause.
Be clear, Your Honor, does that include him holding the...
Absolutely everything is dismissed for lack of probable cause.
Okay. PA 53 then would be time served?
Time served.
I will say any decision on the other front will be made by someone who's not meeting it.
I understand.
Thank you, John.
Best wishes to you, sir.
Thank you, Your Honor.
Whoa. I'm glad we stuck around for that. Holy cow. The judge retelling that whole...
Yes, they're right there.
Thank you.
He's like, my boss is going to decide if we're going to prosecute her, Your Honor. I don't make that decision.
Sure. Yeah.
I'll be in my office.
Need some help out the door?
Oh, okay.
Okay.
For once, I don't have anything in the afternoon.
Okay.
It's possible that the judge...
There was somebody in the waiting room, but...
Oh, my goodness. Holy smokes. It's possible that this judge made a mistake right there.
Thomas Riley's client. Yeah, well, it's too late.
It's possible she made a mistake because they do have hard evidence. There were new charges that were brought that did not rely on the testimony of the witness directly. It was video evidence that him holding the gun as a felon, as a convicted felon, should not be in possession of a gun. They had a witness from the pawn shop that said, yes, he came in holding the gun, put it on the counter. 2 witnesses, basically, that say he was holding in possession of the gun. That charge, I think, legally should have stuck. But the judge looked at his whole case and said, this was a setup. This is a conniving woman. She used that word, conniving master manipulator who set this whole thing up and lied to kick it off and lied in court. And wow. The prosecutor does the walk of shame out of the courtroom. With his tail between his legs, having been gotten a severe whooping from the judge. All charges dropped. I don't, there's probably, let me just say, those 2 should not be together. I realize they have a child, okay? That's an issue. It probably needs to be sorted out in court, and they just, custody, get that sorted, okay? That's why we have family law lawyers. Those 2 should not be together. I wish I could hear what the judge was saying now. Yeah, it's dismissed. It's done. It's gone. Yeah, go have a drink with Jay Regier. 2 prosecutors get their tail handed to them. This was a case where the prosecutor walked in with the video evidence of the defendant, a convicted felon, committing a felony. Authenticated evidence, and the case got thrown out. Wow. What a move by the judge. That's a bold move. Unfortunately, I am concerned still that the underlying situation, that tensions between those two, it's not over. And I would hope that nothing bad happens going forward. I hope they can just be separate and stay separate. Be okay. He overcharged based on a terrible witness. He did. Oh, wow. Should have been in the beginning. Yeah. How long has he sat in jail? How long has he sat there? Way, way, way too long, I can tell you that. All right. Let's see what Judge Simpson's up to. Let's go check in on him before we go to lunch.
He didn't catch it this time. Or did it on purpose?
You don't?
No, my name. It's Mika, not Micah.
Oh, so you went up and just what? I call 1,000 names a day, and you're gonna pick on one. No, never mind. No, I'm done. I do the best I can. Sit up here. I sit up here and I try to dispense justice, and you can call me out on one. You and her. I know Gaines is involved in this someplace. Fine. What are we doing?
Your Honor, you should have a plea form for Ms. Addison.
I do.
I think
plea form indicates that she's going to plead
Judge Simpson's the
guilty to the charge of possession of a firearm on the restricted premises, a 90-day offense. Upon her successful plea to that charge, count one would be dismissed. And there's a sentence agreement between the people and defendant. She can be sentenced under the prosecutor deferred program, which is really what this would be. All right. That's the court's full understanding. Is that correct?
That's correct, Your Honor.
Now, what's your first name again?
Mika.
Can we have Mika sworn, please?
Do you solemnly swear to affirm the testimony you about to give the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Mika Addison.
You knew that. Ma'am, is this court's understanding that you're going to be pleading guilty to the charge of possession of a firearm on restricted premises? That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. I think it also requires forfeiture of the device. I'm not sure.
Well, they already have Stella. I'm sorry, the gun. I call her Stella, but they took it at the time.
Stella?
Yeah, they took it at the time of the offense, and I just
Stella.
Yeah,
she named her.
That's my girl. She protects the house. Okay, I have two daughters.
Stella. Anyway, go ahead, buddy. It does. All right.
But they already have it. They took it at.
I know, but
I just never filed for it back because I knew better. So they already have it.
Knew better, except to name her gun Stella. All right. Anyway. All right. So it does require mandatory forfeiture of the weapon or device. You understand that?
She's gone.
Yes, she's gone.
I warned her already. I hear a Hall & Oates song in my head.
Understanding that, ma'am. Do you still wish to plead guilty?
Yes.
To the charge of possession of a firearm in a restricted premises, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You had signed an advice of rights form, is that correct?
I did that right.
Yeah, that's the one.
Yes, I did.
Any questions regarding any of those rights?
No, ma'am. Or no, sir. Sorry. I was talking to, no, sir.
Mm-hmm.
Would she bring a gun into court or something?
I knew it.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or you're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty?
Yes.
November 14, 2025, at the location of 1500 East Medical Center Drive in the city of Ann Arbor, Washtenaw County, state of Michigan.
It was a hospital.
Did you have a pistol concealed on or about your person?
Well, it was January.
What did I say?
It took them until November to even say anything, and they picked me up at home. But yes, I was at the University Hospital in January after a car.
Did I say January 14? I said February?
After a car wreck?
No, I don't. I really don't.
Me either. I understand.
But, all right, let me do this again. January 14, 2025. Location of 1500 East Medical Center Drive, city of Ann Arbor, Washtenaw County, state of Michigan. Did you have a weapon on your person?
Yes, unfortunately.
All right. And you were carrying that weapon, and you understand that in carrying a weapon, even as authorized under CCW that or CPL, that there are certain places you cannot carry that weapon.
I absolutely do, which is why it was a total accident. Like it wasn't. I've had that gun since 2018, never had a problem, and that was literally a slip of the mind after the car accident. So I did it. I just didn't.
Well, okay, but you understand, right?
Yes.
And you understand that one of those prohibited areas is a hospital.
Yes.
All right. Ma'am, I do have to advise you, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
I do also have to advise you before I take your plea, you understand I'm taking your plea, but you would be sentenced by Judge Garwood in the 15th District Court.
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court. Sentencing will be
March 17th at 9 a.m.
March 17th, 2026, 9 a.m. before Judge Garwood. And in finishing this, bond is continued and Stella gone. No. All right, thank you.
All right. All right.
Thank you.
Thank you.
I think that's it for me. You think so? It's probably long overdue. Court will stand in recess.
All right.
Judge Simpson turned on the closed captioning on Zoom. That's why we have those. Man, I've got a sneeze coming on. All right, let's see. We have a little bit of time before we go to Judge Stephanie Boyd. Stephanie Boyd trial is going to start at 2:30 for her. She's actually live right now, so we can go down there and see her working on her docket pre-court.
Just in terms of my client,
Stella gets destroyed.
Willing and wanting to go through the safety program.
Okay.
And so that's not an issue. We agree with some of the issue. And his situation, Judge, is, you can see, has been a constant struggle with the drugs. But it's not a situation where he just given up on that struggle. He's been in the fight, and although a lot of times the drugs have an upper hand, but he's still fighting the fight.
Yeah. So I mean, that's why I'm giving him two choices.
Right. So I understand. Well, the prison. Oh, that's all those things. Not a solution. But a choice. What we would ask the court to do is allow him to go to the safety program.
Oh, no.
When he comes back, then the court has some other assessments in terms of what he needs. Then I would prefer the court make a decision. Then the court would have an opportunity to get an update from the program, how well he's doing. and get an opportunity to see.
Oh, no, I'm just asking. If you want today, I will revoke you and sentence you to 3 years in the prison, or I'll deny the motion and you can go to safety. Those are your two choices.
I think we agreed on the safety.
No, I mean, here's the thing. You know yourself better than I do.
Yes, ma'am.
Better than anyone else. So that's why I'm giving you the two choices. I am hoping that you choose safety. I'm hoping that you be successful. But I'm just saying, based upon this is not the first time that you've been before me for a violation of number 2. And I've added conditions to help you. I just don't know if you will be successful. So therefore, I'm giving you two choices. 3 years in prison, or either you remain in custody for transfer to safety. Which do you prefer?
Safety.
Okay. All right. Ms. Abrams, 2 will be true. Deny the motion, alternate amend conditions. He's to remain in custody.
Parenting classes.
For transfer to safety. Or if felony drug court accepts him, he can go to felony drug court. That's it.
That's it.
Okay, I already felony drug court.
Oh, it's completely up to them. I have no control over your being placed in the program, but yes.
Judge, I don't think felony drug court is going to accept him.
Oh, that'll be tougher. Now you get 3
And
years.
you can talk to her and she'll tell you why.
Yeah.
All right.
That's fine.
Too many strikes.
Thank you very much, sir.
Thank you.
The judge is rocking, it looks like a Patricia Nash Navarra woven leather purse.
Just give me one moment. Yes.
Haven't seen that one before, but I know my purses. That particular one usually runs about $300. You can find that on sale for about $200.
Safety, he has to have 2 years remaining on probation. At this point, he only has a year remaining.
All right. So we're going to have to extend him for the 2 years.
Years?
Yes. Sir, you're going to be extended for 2 years because of the program.
If he completes successfully, would the court entertain early termination?
Always am available to entertain any motions that are brought before me.
Appreciate it. That's refreshing. Thank you.
All right. Thank you.
A few more people there in court. What judge does is she tries to handle all the cases she can before the docket starts, before the jury shows up. So she'll be working right up until lunch. Then after lunch, the courtroom will sort of clear out and we'll proceed with the case we started on yesterday, the murder trial. Did go back and watch, they sort of went on break. They had just called like a Dr. Fitzgerald or something. He never took the stand yesterday. They never came back from break. So we expect to have Dr. Fitzgerald on the stand as our first witness once we start after lunch today. But let's give the judge a few minutes to let us know what sort of mood she's in today.
They keep saying no match found.
SafeP, I believe this is it's a program for drug abuse recovery, drug and alcohol abuse recovery and treatment. And it keeps you out of violation. I think it's in-house, right?
Yes.
Yes, judge said yes.
Letter, and I've written the address on there, so the court has the address.
Walker.
All right.
Oh my goodness, I'm sorry.
State on this Monreal matter.
It's a murder trial. 24 years ago, the suspect was on the run in Mexico and returned. He's charged.
All right. And what date would this
shooting up a drug house after a drug deal gone bad. Killed one person, wounded 2 others.
I think
defense says it wasn't him. It was the other guy.
He'll have to call and get the appointment scheduled, and we weren't going to do that unless we knew that the court was.
All right. I will tell you this. The fact that I'm allowing you to apply for that doesn't mean that I'll allow you to attend. I haven't made up my mind on that, but I will not make a ruling on this until you give me a specific date and time.
Thanks for dressing appropriately for
Judge,
court.
would it be possible for him to call pre-trial that day and then?
He has to give it to me because I have to make a ruling on it.
Yes, sir.
All right, thank you.
So, just so I know,
And he can appear by Zoom.
He can appear by Zoom, or would we be required to file another motion or a different motion?
No.
Okay, thank you, Judge.
Who's next?
Page 2 at the bottom, Melissa Fajardo.
Marissa Gallardo. No. All right. Where we're in Discovery, I know we had a warrant or something.
They did tender the search warrant, Judge. I'm happy to sign off on the discovery acknowledgement. I was given an offer of pretrial diversion, so I'm going to submit that application at the fourth floor today, just hoping for time for that process to occur.
All right, I need a PTD date.
March 19th.
All right, so y'all just make sure everything is filed with PTD, the application, before you come back on March 19th.
Will do, Judge.
Once you sign that, your excuse.
Thank you, Judge.
All right, thank you.
That was sneeze number 21.
Judge.
Yes.
I think the judge is secretly a
right,
purse
who's next?
influencer.
House, Tory House.
She could make a killing.
What page?
Like, get the manufacturers just to send her purses.
All right, House.
The only thing
Application.
the only thing I don't get is does she dump out her
Probation,
purse
there's an application.
every day, or does she keep
Sorry,
stuff in
folder
all
judges.
her purses?
Okay, thank you. And is there just a plea on one?
Correct. There should be 2 dismissed tendered for you.
All right, court is calling 2025 CR 013596, State versus Tory House. Can I have parties announced?
We're underway for Mr. House.
And are you Mr. House?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
He's as
Court will
tall as
find
a
that the
barn.
state is in compliance with discovery. Mr. House, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
See this proceeding on count 1, paragraph F, Your Honor, we will waive the remaining paragraphs.
Any objection?
No objection, Your Honor.
I'm so sorry, State. If you can write another dismissal, because they like to sign their own, I should say. Mhm.
Also give it to Judge Key.
Okay, thank
Got
you.
it.
All right, Mr. House, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, and count 1F, you're charged with burglary of a building. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Sure.
If I were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir.
Counsel, has your client been able to provide you with defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. House, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1, paragraph F. There's a $1,200 fine. State is recommending deferred adjudication.
I can show
They're
you the
taking in
image.
consideration 2025 CR 013595, 2025 CC 015356, and there's to be restitution, if any, to the following per.
Why'd we lose audio there? That shouldn't have happened. Two more sneezes, sorry. I don't know why. Audio's gone. She's like, just
Defense?
Yes, Your
she
Honor.
muted on her end. Okay.
State. Yes. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, the anti-theft course, a felony drug court referral,
Parenting
and
classes.
if not accepted, SafeP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to count 1, paragraph F, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. State offers states exhibit 1 in all attachments.
No objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call on the right to remain silent.
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Well, she reviews those same documents. We're going to be going to lunch here in just a minute. And when we do, I think we're going to take about an hour and a half lunch, which will give me time just to lay down. The cat naps in the afternoon are helping I'm just getting tired, and I want to be here sharp as a tack for when Judge Boyd comes back with
All right,
part 2
after
of this
reviewing
trial.
states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just that the court follow our agreement.
All right. So do you have any children?
No.
No parenting
Do you have any
classes.
family support?
Yes.
All right.
They are present in the courtroom, Your Honor.
Okay. How far did you go in school?
College.
Okay. So how did you get on this path?
Just being around the wrong people and just not following like the path that I was on out of school.
Well, you know, when people come before me and they say they're around the wrong people, like the other suspect in this case, if I were to talk to him,
Right.
he would say, I'm around the wrong people. And I'd say, who would that be? And he'd say you.
Right.
So how old are you?
I'm 33.
All right. And so how long have you been using?
For like 5 years.
And what were you using?
Meth.
Okay. All right. So it's obvious that you're going to need some help with drug addiction. And is his family members going to allow him to live with them if they?
That was part of the issue that we were discussing, Your Honor, hence why we, after conferring with the state, they want him to go to felony drug court, and if he's not accepted, to go to SafeP. And upon his release, if he's successful on this rehab, then they would consider him being able to live with his mother.
So his mom is here?
Yes, Your Honor.
Can I speak with her?
Sure.
All right. If she'll come up.
Come on up, Mom.
Might have difficulty. She is in a wheelchair.
It's all right.
Let me
She
help
can
her.
still hear.
Sure.
This is what my paper wrapper sounds like, Red Pen. That's it.
Hello. All right, so here's the thing. I'm going to grant his application for probation. But when people have drug addictions, it has to be a global support system, right? Probation can't help him if you're not helping him. So that means if he does come to stay with you, you're going to have to lay down the law and there's going to have to be consequences. And if he's not following those, you're going to have to pick up the phone and call probation. Your attorney will tell you if somebody is on probation and they call probation and say, hey, I think I'm going to use, what's going to end up happening in this court? I'm going to set it for a compliance hearing. They're going to come in and we're going to see what help we can give them. But we can't have people disappearing and not reporting, and then they don't report and say, well, I got afraid, so I never showed back up, because that limits options.
That's the circle we've been in.
All right.
We've done rehab. We've tried rehab.
Okay.
And I've been in the circle with my son. And that's why I was talking with his attorney, explaining that just throwing him back out there, I don't think we'll be setting him up for success.
Okay.
To be truthfully honest. So when they said inpatient treatment, I think that would be the best.
All right. So
I'm there to support. I'm 1,000% for my children, but I don't want to see him come right back up in front of you.
But you're strong enough for him to have consequences for actions.
Yes.
All right. So I can tell you what I'm going to do. I am going to refer him to felony drug court, and you'll need to talk to them to see if they have room for him.
I already talked to Rashad about that, so it should be good.
And then what I'll do is, if he's accepted a felony drug court, I am going to put him on GPS with a curfew. And so we'll know where he is.
Would the court consider waiving the GPS fees just because of his indigency status?
Yes, the fees will be waived, but that's so we'll know him. Because right now he's going to have to build up his level of trust with probation, and felony drug court makes them build up the level of trust before he's allowed to do other things. All right. Other than the drug treatment, is there anything else that he needs?
No, I think maybe mental health.
Okay. A felony drug court, they have a dual diagnosis program, so they'll address any mental health issues with any substance abuse.
Yes. And I think between those two, he'd be smart. Academic scholarship to Texas Tech.
Okay.
Smart kid.
Mm-hmm.
Youth orchestra.
Oh, wow.
Youth orchestra. He can play violin, viola, cello, bass.
Oh, wow.
Wow.
He was very talented. He got mixed up with the wrong people, and I couldn't get him back.
People. All right. Well, we're going to try to get him back on the right track.
He's a good kid. He really is.
Okay.
It's down in there somewhere.
This is from one mom to another here.
So
heart to heart.
I'm going to grant his motion, and we're going to see about getting him some treatment. So if felony drug court doesn't accept him, that means he'll be going into an inpatient treatment. And even if he's accepted in felony drug court, they'll set his conditions. So they may decide he still needs inpatient treatment as well. Okay.
Thank you so very much.
All right. You're welcome.
And just
Thank you.
Can you state your name for the record?
Yes, Vanessa Smith.
Okay.
Thank you.
All right. Thank you. And if you'll make sure she gives probation her information.
Sure, Your Honor.
All right, Mr. House. All right, so this is what I'm going to do. When's the last time you had any type of employment?
It's a couple of years.
Okay. We're going to do our best to get you back on track, all right? So I'm going to send you to 4 years deferred adjudication. There's to be a referral to felony drug court in custody. They'll probably be able to see you on Tuesday because it's late in the week. If not accepted, then safety. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors. Partial GPS for treatment, waive GPS fees, field visits 1 time per month until further notice, 120 hours of community service restitution, see. There's a $1,200 fine. That will be probated. Take in consideration 2025 CR 013595, 2025 CC 015356. Restitution and no, if any, and no contact with the following.
This may seem like a harsh sentence. The judge mutes the microphone for the names of the possible victims in this case, or people surrounding this case, as well as maybe some co-conspirators. So, man, his mom's there for him. It's like he's got some talent. If he can play, if he's good at music, he's probably also good at math. I think those two run together. I was bad at both, so that's why I think that. But if he's applied himself in life and been able to at least get that far with musically, I think he would be able to apply himself career-wise and either pick up a skill or a trade and be able to excel at that as well. Hopefully he can get clean. Meth is a monster. It's an addiction that will just, it destroys your body and your life. It takes it all. So.
Successful. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
It's 33.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, you're gonna have to do better. If you don't do it for yourself, do it for your mom. Get back into playing your instruments, okay? All right, good luck to you.
Thank you, Your Honor. Very briefly.
Yes.
Have a seat, sir.
Get back into playing your instruments. Find joy in creating music. It's a beautiful thing.
Who's next?
It's a gift.
Lopez, Judge, page 3 at the bottom, seat 7.
And I'm not talking about Suno songs. Those don't count. As much fun as they are.
Okay.
All right, it's 12:45. We're going to be coming back at 2.
And I'm sorry, what was that page again?
Which is an hour and a half from now.
And then page 7. Yeah.
All right, Robert Lopez.
Roberto Lopez. Music's amazing. Music is powerful.
There are no applications, right?
Correct.
Okay.
I base my belief that math and music goes well together on the fact that I can't do either very well. So clearly the other people can. It's reverse logic that does not really apply very well. All right, I think we're going to call it right there. I'm ready for my afternoon nap, a little siesta, so I can rest up and be ready for the day as we move forward. Jen Pookie, member for 31 months, says before we go, looky here, OG. Jen, thank you very much. 31 months. Love that color courthouse. It's about to change. I will set my alarm so I won't sleep through it. It will be good. We'll be good. It's going to be great. So, all right. Let me find the music. Any music will do. Not the verdict music. I had a different song in there somewhere. Maybe we should do this one as intro outro. All right, everybody, thanks for joining us this morning. We've had some fun jumping around some courts, seen some unexpected outcomes with a dismissal of all charges when the defendant was caught on video with a gun in his hand. The problem, he was a felon. The judge still threw out the case because the woman who testified against him lied, and she lied, and then she lied again. And the judge called it just the way she saw it. Saw some good stuff. We have a court case coming up today in Texas, Judge Boyd's court. It's a murder trial, and it's an old one. It's almost like a throwback into how courts used to be before all technology was like every piece of evidence was technological. Now, we're going to be thrown back to memories of people who retired long time ago, can barely remember the case, let alone their career. And it'll be interesting to see if we can get a conviction. So, That said, you guys, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again at 2:15. 2:15 it is. All right. See you guys. Out. See, that wasn't too bad, was it?